Right. I actually called my mother.
Yeah.
My mom used to send me.
Which is hard to hit.
She had an MSG where she where you know the hey mom, let's
Since you know the cases so well.
Hello.
Alan looks like he's ready to start.
Sounds really
Very
neat.
cool.
Yeah.
You really like
I'm
it.
looking forward to it.
You really like
All right, thank you, everybody. My name is Alan Steinbrecher, and I'm the chair of this committee. This is the first meeting of the California Attorney Practice Analysis, or CAPA, working group. Welcome, everyone, and thank you, first of all, very much for agreeing to participate in this working group. I apologize for getting everything started 10 minutes late. Sometime during the next year, as this committee goes along, I hope we make up those 10 minutes. My flight was a little delayed getting into San Francisco because of fog, something that probably will come as no surprise to most of you. But in any event, here we are, and again, welcome everyone. A couple of brief remarks. This is a continuation of a number of studies that the State Bar has undertaken over the last year or so to evaluate various aspects of the California bar examination. It's been looked at from a couple of different directions, and this is another key component of that overall study of the bar exam. This, of course, the purpose of this study is to determine what are the practice needs, what areas will new attorneys be starting in general, and therefore what is the proper content of the exams. All of this will be discussed in greater detail by Ron Pye and our consultants as we go through the day, but that's just to set the format. This meeting is being webcast, so as a reminder, please remember that we are speaking not only to ourselves here in this room, but to a live and subsequent audience, and for anybody who's listening in on the phone. So be sure that when you are talking, that you turn your microphones on. Generally takes a double click and gets the green light. So talk into that, identify yourself, and then speak somewhat clearly and distinctly so that everybody will understand what you're saying. We won't go into all the formalities of the meetings in terms of, because we're not going to be taking votes probably, so we'll just get right into the meat of this meeting. But I do want to emphasize that we are conducting this entire study group pursuant to Bagley-Keene, which is for those of you who may be unfamiliar with Bagley-Keene, it's a statute in California, which is designed to allow the public to have information and insight and even participation in the deliberation of governmental bodies such as this. So because of Bagley-Keene, we have to be aware of restrictions on discussing subject matter that this committee will be discussing in other than public settings that have been prearranged like this. If you choose to, at some point in the future, try to participate by telephone, your address where you will be that is ADA compliant and open to the public will have to be published. So just as one little example of some of the strictures of Bagley-Keene. There's a Bagley-Keene handout in your materials. Please take a look at it. It's a little bit hard to get used to at first, but please take a look at it, make sure that we're doing the right thing by complying with Bagley-Keene. And if you have any questions, you can ask me, who I will then refer you to one of the staff members here who knows it a lot better than I do. Okay, so with that, we're going to get underway, and I'm going to go around the room and ask everybody to give a very brief introduction of themselves, since we are, by and large, not familiar with each other. Again, my name is Alan Steinbrecher. I'm the Vice Chair of the State Bar of California this year, and I have participated with Ron in some of the previous studies. I am an attorney down in Los Angeles. I was with a large law firm out of law school, and then started my own litigation and corporate boutique about 13 years ago, and managed to survive in that environment as well. So that's my brief story. And Ron?
Over to you.
Hi, my name is Ron E. E or Pi. When I visited my son this summer in his college, I met his friends, and his friends started calling me Mr. Pi. I said to my son, when did you change your name? That's the first thing they do after going to college. So I'll go with either one. I've been with the bar for 2 years. I've been involved in bar exam studies. I'll go over some of those key elements in the studies and then leading to the current study in a little while. And working with us is to the right, next to the consultant from Castle. In addition to Josh McInnes, we also have the conference line, Jim Henderson. He is the Vice President of Castle Worldwide, and he's joining us today via telephone. He was originally planning to attend in person. He wasn't able to because of a family emergency, but I'm very grateful that he was able to make it by telephone.
Hi, my name is Josh McInnes. I'm a psychometrician with Castle Worldwide. As a psychometrician, that means that we're in the business of creating tests. I've been with Castle for about 3.5 years while I worked on my PhD and recently started full-time about 7 or 8 months ago. Prior to that, I was in K-12 testing. I was a teacher and a subject matter expert in item writing. So I'm quite familiar with the testing industry going back about a decade or so.
Thank you.
Hello everybody, my name is Eli Wallach. You may have been receiving emails from me. I'm the meeting coordinator today and for this working group. I'm the working group coordinator. I'm also a program analyst in the Office of Research and Institutional Accountability, where I work under Ron. And I'm here to help facilitate this working group and execute this study, and I look forward to working with you all to do this. Thank you.
Hello, my name is Jackie Gardina. I'm the Dean of the Santa Barbara and Ventura Colleges of Law, which is one of the California accredited law schools, for those who may not be familiar with it. I joined the school about 2 years ago, 2.5 years ago, coming from a traditional ABA background. Since this is the practice working group, before starting to teach, I also practiced at a firm in Boston called Paul & Stewart and clerked at the Federal District Court and the First Circuit Court of Appeals. So I'm excited to get started.
Hello, good morning everyone. My name is Sarah Cassidy. I am a labor and employment attorney in Sacramento, representing teachers, school districts, charter schools, and I also work with the ABA very frequently. I am the chair of a few different committees, and I do some writing, speaking, and editing for them as well.
Hi, my name is Hatem Kalik. I'm the Director of the Office of Research and Institutional Accountability at the State Bar. And I'm involved here to support Ron in this particular study and the group as well. And I participated in some of the other work that Ron has done as well. So.
I'm David George, Corporate Counsel for Geocenter Consultants. It's an environmental firm in Oakland.
Hi everybody, I'm Robbie Brody. I'm an administrative law judge in Los Angeles. I'm on the Committee of Bar Examiners with the State Bar, and I am the Committee of Bar Examiners representative here on this committee under my boss, Amy.
Hi everyone, my name is Shanae Buffington. I'm an attorney at the Employment Development Department. I am Vice Chair of the Client Security Fund Commission, and I am also First Vice President of the Sacramento County Bar Association.
I'm on the Eastern Time, so I'll say good afternoon. My name is Aaron Taylor. I'm the Executive Director of the Access Lex Center for Legal Education Excellence. We're a nonprofit based in Washington, D.C., and our goal is to make legal education more efficient, more effective, and more equitable. And one of our priorities is to help increase bar passage rates, first-time bar passage rates nationwide. So that's why we're interested in studies like this, and that's why we were eager to serve as a funder of the work.
Good morning, I'm Emily Scivoletto. I'm the Associate Dean for Academic and Student Affairs at UCLA School of Law. I also teach professional responsibility and leadership in the law. And prior to UCLA, I've been at a couple other law schools, can't keep a job. But before that, I practiced for 6 years as a civil rights and business litigator in Sacramento.
Hi, good morning, everyone. My name is Steffi Jose. I'm an attorney with a boutique appellate firm here in Walnut Creek as an accounting lawyer. I sat and passed the bar not too long ago, so hopefully my recent experiences will help with this working group.
Good morning, everyone. Can you hear me? I'm Sylvia Kennedy, and I work with a nonprofit. I work with Senior Adults Legal Assistance in San Jose. And thank you. And we provide free legal services to seniors in Santa Clara County, anyone 60 and over who lives in our county. Prior to that, I worked as a deputy county counsel in Santa Clara County. And prior to that, I worked with other nonprofits.
So good morning, everyone. It's my pleasure to be here. I am Judge Glenn Reeser. My youngest son has moved to Japan, works for Mercedes, and he pronounces it Riser now. That's a kudo to Ron there. For 20 plus years, I was a trial and appellate litigator in Ventura County. For 20 plus years, I've been a Superior Court judge in Ventura County. I have another 19 days, and then I'm going to be a neutral with JAMS.
Good morning. My name is Donna Hershkowitz. I'm the Chief of the Programs Division here at the State Bar of California. Among the several programs in the Programs Division is admissions, and that is why I'm here joining you today.
I'm Sunil Gupta. Folks just call me Neil. I am the Chief Justice's principal attorney, and I'll be joining this committee as her liaison and also the liaison to the court.
Well, it's not lighting up. I'll speak loudly. My name is Greg Murphy. I'm a lawyer from Montana, and you might be wondering why is a lawyer from Montana in the California Working Group. You'll have to ask the Supreme Court, but I suspect it's because the National Conference of Bar Examiners have nominated me. I have a background in legal education and in bar admissions. Montana Supreme Court appointed me to its board in 1985, which is beyond the memory, I think, of some people here. And I went on to chair that board for many years. I chaired the Multi-State Bar Examination Committee of the National Conference through most of the 90s. I chaired the conference in 2000, 2001. I'm not on the board now. I went on the ABA Law School Accreditation Committee and chaired that committee in the early 2000s. I just completed recently my term as chair of the council, the section of legal education and admissions to the bar, which, for those of you who are not familiar with, is the national accreditor for law schools. I chaired the multi-state, Uniform Bar Examination Committee. I taught at Cornell for a brief period. So I've got some background in legal education and in bar admissions. And interestingly enough, I was involved in the 2012 NCPE job analysis. So I've got some background in that, and because of my work with the MBE for over the years, some rudimentary understanding of psychometrics. Josh, I'm not a psychometrician, but I've been dealing with it for close to 25 years or more. Thank you.
Good morning. I'm Amy Nunez, Director of the Office of Admissions. Thanks.
My name is John Palmer. I'm a partner at work, Harrington and Sutcliffe. I practice public finance.
Hi, I'm Cindy Mayfield. I've been a judge in the Mendocino County Superior Court since 1997. I was a civil litigator before that. I think I'm probably here because as a small county judge, I've done civil and family and juvenile and criminal and probate. So maybe I have some idea about what lawyers need to know, a little bit of everything.
Mr. Chair, if I could note, one other member of the committee, Margie Estrada, the Chief Counsel to the Senate Judiciary Committee, is currently participating in the Legal Services Trust Fund stakeholder meeting that the bar is hosting, and she will be calling into this meeting when they break.
We also have another member who cannot join today, which is Professor Justin McCreary from Berkeley, and he's going to Columbia next semester because a lot of other kinds of responsibility and transition. He originally was able to come, but today he is absent. So aside from those, we have everyone. And we should also give Jim an opportunity to introduce himself via telephone. Jim?
Yes, thank you, and thank you everyone for being part of the conversation today. As Ron indicated at the beginning of the call, I am the Vice President at Castle Worldwide. We are a Scantron assessment solutions business. Scantron, of course, is the company that is famous for its bubble sheets, and but the company has been very busy in expanding its product offerings through time, and we are a recent acquisition. The company, Castle, has been in existence since 1987, and during all of that time has specialized in examinations that are used in the licensure and certification of professionals in many different capacities. And so we are very excited to be joining with the California Bar to conduct the practice analysis study that is beginning with this meeting. I look forward to the conversations that we'll have today to talk about what the project is all about, why we are conducting it, and then also we'll be looking to you as a group to give some guidance on different elements of the study. As Ron indicated, I had planned until just a couple of days ago to be in attendance on Sunday. However, events conspired against that, and I am very grateful to you for allowing me to be here in North Carolina so that I can support the folks here who need me to be here.
Thank you. All right. So again, everyone's introduced themselves. We are now a happy working group, and we are ready to proceed. This is the time when we want to ensure that any member of the public who has any comments to make to this group has the opportunity. So I'm now calling for public comment. I don't see any other people in the room other than those who are sitting around the table, so I assume there's no one present who wants to address the committee as a member of the public. Is there anyone on the telephone, attending by telephone, who wants to address this committee now? Hearing none, then we will proceed with the agenda. And I should say that this meeting started at approximately 10:10 this morning. I should have noted that on the record, but belatedly, we started at 10:10. So, moving forward to the next item on the agenda, D. Ron is going to discuss the previous bar exam studies, unless anyone has any questions at this point before we begin. All set? Okay, thank you. Ron?
So the previous studies that we launched in 2017 is really just the impetus for the current study on practice analysis. From early 2017, the first study was using the bar admissions existing data to look at changes in bar performance over the past few years. And that was somewhat limited to look at the different factors that might have affected the bar exam performance changes. And following that is another study that required, that solicited participation from law schools, and at the end we had 11 ABA law schools joining that study that entailed the law schools providing us with very detailed student information. And that study, we finished a draft report and currently in the review process. And that will tell us a lot about the different factors that affected the changes in bar performance in the past almost a decade. The other two studies really are more directly related to the bar exam rather than performance or changes in the bar exam from the applicants. So those two studies, one is standard setting that's related to evaluation of the existing cut score to see where that cut score would be appropriate, and using what's called an analytical judgment method, we convene a panel to, based on their judgment, looked at past bar exams, and the study recommended a range where the cut score could be considered appropriate, and ultimately the recommendation was submitted to the Supreme Court, and the decision was made to pending additional information and not to change the cut score at 1440. Content validation following standards setting conducted by the same consultant, Dr. Chad Buckendall, that is focused on the alignment of the bar exam content. And as usually for this kind of a content alignment study, the basis for that evaluation is using a job analysis result. And for that study, we used, as Greg mentioned, the NCB's 2012 job analysis study as a way of comparing the practice content with the California bar exam. And for that, we used the written portion of the bar exam to make the assessment of the content alignment. And recommendation of the study, the key point was there needs to be a more up-to-date and as well as California-specific job analysis study as the basis for doing a more comprehensive analysis of the content alignment of the bar exam. And that's really the direct impetus for us to be here today, so that we can start from the foundation of this series kind of a study. Usually it starts from practice analysis and going into content validation. After the content is validated to be consistent with the practice, and then the next step is standard setting to evaluate where the cut score should be. That's typically how it's done. And so we're going back to the beginning of this cycle. Some additional background information that made it important for us to this study is a statutory requirement that was passed last year that required the State Bar to do an evaluation of the bar examination every 7 years. And also based on professional standards for exam administration, standards from educational and psychological testing, it stipulates that the content domain covered by a credentialing test should be defined clearly and justified in terms of the importance of the content. And the purpose, the study, we're expecting to use the result of the study to achieve these specific goals as listed here. One is to ensure the exam content in terms of breadth, depth, and complexity of the exam is related to knowledge and skills required of entry-level attorneys. That's why members of the working group with just out of law school, and that's a very important element for us to be aware of. And provide also a documented link between exam content and current legal practice. This is especially important for licensing and certification kind of exam, to have that kind of a legal justification for what's covered on the exam. And also assess the adequacy of the exam format. Given at the end what we know about what the practice requires, different kinds of skills and knowledge, the question is what are the appropriate format to test the knowledge and skills. So that's partly within the scope and for the working group to discuss after the completing the survey, to what extent we should use the results of the study to assess the different aspects of the exam. And following the exam, the analysis of the results, for administration of the examination, it provides a blueprint for question development and selection over time. Once you have a question item bank, then every time you want to make a decision about the specific questions to be included in any specific exam, this will give us a blueprint about the balance of the questions that should be covered on the exam. It will also inform development of minimum competence definition, which is the foundation for evaluating the cut score standard setting exercise. I'll go over the methodology for the survey a little bit later. That's later item. Now we'll shift to the next item, E, what is practice analysis? And Josh will.
All right. I will, at times you see Jim Henderson's name on this as well. As we mentioned earlier, I am representing Jim today, and he's representing himself on the phone. So if he wants to add some more to the conversation or the presentation after I finish, then I'll turn it over to Jim and give him an opportunity to do that. As I mentioned earlier, I am a former high school teacher, so I like to assume when I'm presenting a topic that there may be someone in the room that knows all of this, and there also may be someone in the room that doesn't. So if you know all of this, I apologize, but there may be someone in the room who appreciates it. So my goal here is to talk about what is a practice analysis, why do we do it, and how do we do it from a 30,000 foot view for this part. So a practice analysis is a systematic study of a profession to identify tasks performed by newly certified individuals. In credentialing, it's the gold standard. It's usually the primary source of validity evidence. And I'll talk in a little bit more detail about why we need that validity evidence in just a few moments. But the end products of the practice analysis, or at least the middle products of the practice analysis, is a hierarchy of domains, tasks, or subdomains, and knowledge or skill statements in the form of a content outline. As Ron mentioned, that content outline ultimately will be validated, but the first part of the practice analysis study is to delineate those things. Domains are the major areas of responsibility. For instance, an example I like to use is if we had a baking exam. We had a baking certification, and one domain might be baking pastries. That would be a major area of responsibility for a baker. The tasks or subdomains is an exhaustive list of specific responsibilities or topics that fall within that domain. So using that same baking example, it might be cracking the eggs or knowing what ingredients to use, things like that. And then finally, the knowledge and skill statements describe specifically the knowledge and skills required to perform the task. So, knowledge of knowing how to operate an oven, or once again, knowing the ingredients is probably a better knowledge statement than task statement. So there's a couple of different ways you can approach this. One is more from a task or an action standpoint, and another is from a just pure content standpoint. And we will talk about those differences a little bit later. The main thing is why do we do a practice analysis? Traditionally, or traditional education has led us to often create tests based on knowledge that was learned. So the test being linked to the knowledge that was learned. But a practice analysis looks at it slightly differently. It links the test to an occupation or a profession. And since the purpose of certification licensure is to assure the public that individuals who practice have demonstrated that they have the necessary knowledge, abilities, skills to practice safely and competently, that's very important in certification licensure. Specifically, Ron mentioned this earlier as well, the standards for educational and psychological testing specifically ask for this validity evidence. There are a number of other standards out there as well, but the standards for educational and psychological testing are kind of the gold standard that goes across all different types of testing situations. So the validity argument is always about interpreting test scores. So we need to be able to say that someone that scores, for example, 110 points on a 150 item exam is, we've got the background validity evidence to show that that person has those knowledge and skills that they need to practice safely and confidently. Validating credentialing exams depends primarily on that link between the content-related evidence and the test, between the test and the occupation. There's a specific chapter devoted solely to credentialing and workplace testing. And I'll go over 2 examples of specific standards that the standards require. All of this to be said, that initial example that I gave about tests being created based on knowledge learned has been tested in a number of legal cases. One such case, Briggs versus Duke Energy, they ruled that the content on the exam was not related to practice, and in fact that it was they were discriminating as a result of that. A more recent test, a more recent case, Risi versus Di Fastano, ruled in favor as well of having tests linked to practice. And forgive me of my if I've said ruling, and I know I'm surrounded by attorneys, so if I've misstated something, I do apologize. That is not my area of expertise, is in testing. So.
Josh, this is Jim Henderson. Can I jump in for 1 second?
Absolutely.
Go ahead, Jim.
Thank you. So what Josh has just laid out on this slide about the standards for educational and psychological testing support practice analysis as the basis for credentialing examinations because it's the right way to go about it. It provides logical, research-based integrity that supports the validity of the test. And so it's the right way to go about doing it. But there is, a strong linkage between the court's adjudication of cases where lawsuits have been filed about the validation strategies used for different types of tests. Briggs versus Duke Power goes all the way back to, it was really the first test of the requirement put forward through the U.S. Equal Employment Opportunity Commission. And as Josh indicated, the Supreme Court ultimately held that the test that Duke Energy or Duke Power had used for the purpose of promoting people to higher levels of employment classifications in the corporation was not sufficiently job-related to be used for the purpose that it was serving. So that was a primary consideration and has really been the foundational lawsuit for most of the court cases related to the validity of tests ever since. The most recent that was before the U.S. Supreme Court, Briggs versus Duke Power is 1971, is a Supreme Court decision, and Ricci versus DiStefano is also the most recent in the U.S. Supreme Court. It's a reverse discrimination case where the Hartford Fire Department in Connecticut had developed an examination program that followed all of the procedures that had been detailed in the standards for educational and psychological testing. Yet they found that there was disparate impact in the way that candidates with different ethnic backgrounds performed on the test. And so the fire department board determined that it was inappropriate to use scores on the test to promote people within the fire department. Ricci, representing the class that had passed the test, filed suit, and it made its way ultimately to the Supreme Court, which upheld the process that is defined by the standards for educational and psychological testing. If for no other reason than you may be acquainted with Ricci versus Stefano for, if no other reason than that this is the case that was made famous when Justice Sotomayor was appointed to the court, and there was a lot of discussion around her appointment because she had been a judge in one of the district courts that decided differently from the way the U.S. Supreme Court had decided this case in 2009. But nonetheless, the point is that practice analysis is the established method, both within the psychometric community and within case law, that supports the validation of tests that are used for high-stakes decisions such as professional licensure. Thanks for letting me interject that, Josh.
Absolutely. Thank you, Jim. Just wanted to point out two specific standards in Chapter 11 that are related to this. Standard 11.2 says that evidence of validity based on test content requires a thorough and explicit definition of the content domain of interest. In the very first line of commentary, it says, in general, the job content domain for an employment test should be described in terms of the tasks that are performed and or the knowledge, skills, and abilities and other characteristics that are required on the job. They use the term employment testing here, but this is in a section where they actually talk about both employment testing, meaning more of an internal test, and credentialing, meaning certification and licensure. So they're not just talking about an internal employment test. And the primary one that really points out that link states that the content domain to be covered by a credentialing test should be defined clearly and justified in terms of the importance of the content for credential-worthy performance in an occupation or profession. A rationale and evidence, which is our jobs analysis, or practice analysis, should be provided to support the claim that the knowledge or skills being assessed are required for credential-worthy performance in that occupation and are consistent with the purpose for which the credentialing program was instituted. And the very first line of commentary states that typically some form of job or practice analysis provides the primary basis for defining the content domain. So it's laid out right there in the standards in Chapter 11 that this is the way that it should be done. Now, the how, some of this was laid out by Ron a few minutes ago. I'm just going to hit a few of the key points, and Jim, you can add to this if you'd like to as well. The general process involves, one thing I didn't put on here is having a representative panel for the practice analysis. But there's usually a literature review, meaning a review of changes to a practice or a job. If there's an existing exam, reviewing that content to see if it's still relevant. The development of a target audience statement and eligibility requirements, because at that point you have defined exactly what you're talking, exactly who those new certificates should be. At that point, the practice analysis meeting usually involves developing domains and either tasks or subdomains underneath those domains, and then the knowledge and skills necessary. From that point on, scales are used to rate the tasks in a validation survey. And then I hate to throw them in the same bullet, but I didn't want to create another slide. Analyze the data, and then there's a process for developing the content outline from there. So just a general flow chart here. You go from practice analysis, you develop a draft content outline. That survey goes out to validate your draft content outline, and then from there, you can develop the final content outline. Jim, would you like to add any additional information about how we do the practice analysis?
So one point, and we'll talk more about this in short order. The focus of this practice analysis is on the work-related knowledge and skill that newly licensed attorneys must have. And we need to keep that target audience in mind in all phases of the project, and you'll need to keep it in mind in all phases of your discussions today. The focus is at that level because that is what that's who is expected to provide services to the public at the point closest to when the license itself is awarded. And so while it's valuable to understand that the focus is on newly licensed attorneys, it's also important to recognize that advanced knowledge that might be gained through continuing study of particular topics in the law certainly is advantageous to members of the public who seek legal services, but deep knowledge and the full level of mastery that might be expected of someone who's been practicing for a long time or who's been teaching law is beyond the level that is reasonable to expect of a newly licensed attorney. So we'll be talking more about that, but I wanted to drop that expectation about the practice analysis in at this point. Thanks, Josh.
Thank you. I have a slide here for questions, but I think that's probably what our discussion is for later, unless we feel the need to do that now. I think we can probably move on.
Well, does anybody have any questions of the general nature at this point before we, yes, go ahead, Amy.
I'm curious about the process for this practice analysis for attorneys, given that in the models that you presented or some of the information that you presented, it sounds like there's been, these professions have a richer history of experience in job analysis or practice analysis. Are there any, I guess, challenges to conducting an analysis at this for California attorneys, given that what we've had in the past has been one that's a national study, and that it doesn't have the rich history that other professions have?
Jim, you may want to speak to this. I know you've spent some time researching what other similar examinations.
And so I didn't hear the question. I wonder if someone could paraphrase it.
Maybe I'll repeat it. So in looking at both, in hearing some of the examples that you've discussed here in terms of other professional exams or high-stakes exams, and the process includes a lit review, are there challenges to conducting a California-based attorney practice analysis given that it doesn't have the rich history that other professions might have, and that the one other study that has been conducted was a national study of attorneys across the nation?
So I still didn't catch all of it, so if I give a partial answer, follow up and hit the points that I missed in the question. My understanding of the question is there anything, because of the limited history and scope of the work done in California for attorneys, is there any shortcoming in the basis that we look at in the early analysis phases and summarizing or building on past work? If that's a reasonable understanding of your question, then let me say that we do have a number of content frameworks for attorney examinations that we are looking at now, and among those, certainly strongly among those, is the work done by the National Conference of Bar Examiners. The most recent of their studies was done in 2012, and actually they are in the process of conducting an update study now with in pretty much the same time frame that we're operating on for you. The background information that we are looking at does focus in on other examinations, other bar exams that are used for attorneys. We also are verifying that the process that we are following in this study is at least consistent with the process being used nationally, so that there we'll be able to make the case that while the process was similar, differences in content are due to the unique nature of practice in California. Does that address the question at all?
Yes, it does.
Mr. Chair, Gardina.
And Ron, this question might go to you. I'm trying to understand how what we're doing with this working group fits into the larger studies that the bar exam is doing. Specifically, the standard setting study that was finished was based on a 2012 job analysis study done by the NCBE, or the content.
Yes.
And those two fit together. Now we're doing a new job analysis that may result in some differences from that 2012. Does that bring into question the original standard setting study that would then need to be redone in light of any changes?
My personal view is it wouldn't necessarily bring into question the validity of the study that we did last year, especially with regard to standard setting, because standard setting really didn't follow the sequence of looking at content validation. It was using a different approach and different material to make a judgment, analytical judgment in that methodology to look at cut score. I would only say by restarting the sequence in the way that typically you would expect the test assessment to be done, we'll have a more comprehensive answer about the content alignment as well as standard setting, which may not be answering your question, because your question is probably outside the consideration of research design. And I'm giving an answer that's thinking about these issues from a research point of view. Certainly decisions about the standard setting and other things goes beyond the limited research consideration. That's beyond mine.
So if I may say from a practical perspective.
Don Hershkowitz.
Yes.
Thank you.
Sorry, Mr. Chair, Don Hershkowitz. From a practical perspective, what we've outlined is that the natural result after this practice analysis will be a new content validation study, which then could lead to a new standard setting study. So when Ron talks about sort of restarting this, starting the cycle again in the order that would be the expected order of this cycle, that would be the process. So not sort of calling into question, as he said, what was done before, but sort of doing it again in the methodologically proper order, where you are starting with the job analysis, and this time using and sort of not relying on a 5-year-old national survey, but doing our own practice analysis.
And just one follow-up question so I can understand. What we're doing here, I assume, affects primarily the California, or only the California part of the exam. Obviously, it would have no effect on the MBEs, or California has no control over that. So what we're talking about is whether or not the essay and MPTs are consistent with California. And I'm wondering if one of the outcomes is potentially, although we don't have any control over the MBEs, the weight given to them. If we find that it's important that new attorneys in California know and exhibit X, and our essay and MPT portion can be weighted heavier than the MBEs in order to recognize the importance of those in California practice.
Will the working group, I'm sorry, thank you very much, Mr. Chairman. Greg Murphy. Will the working group, this group, have an opportunity to consult with the contractor related to who should be consulted on the practice analysis? That is, who you're being surveyed, or has that already been determined? And if it's been determined, will we be informed? For example, we have a judge who's in a rural district, is Brendan. We have a partner from Oregon, and the newly licensed lawyers at Oregon may have to do something different than the newly licensed lawyers before judge. Maybe it's the same, but I'm just thinking there's a practical law is so broad, and I'm just wondering if the castles, if it's performed in the legal area for any other organization, and what's our function here as working group in that context.
Jim, you may want to speak to this. You're a little bit closer to this than I, but having said that, it's my knowledge that the purpose of, it's my understanding that the purpose of this meeting is to educate and make decisions moving forward. So, Jim, would you like to answer that?
Yeah, and again, I didn't hear the question very clearly, so but yes, the meeting today and the purpose of this set of conversations today is to provide direction that we will follow in conducting the study, and then we'll be reporting back as we progress and looking for guidance and additional input as we go. And then also, just to revisit the passing standard conversation that did take place a few minutes ago, once a practice analysis study has been completed and examination that is based on the practice analysis and alignment of the test to the practice analysis content framework is done, then that's an opportunity for organizations like the California Bar to revisit cut score analysis or passing standard study. And it's particularly a good time to do it if there has been a major shift in the content framework of the test. So following practice analysis, exam revision work is done, and when the first versions of the test are ready to be used, then it is common practice, but not required practice to conduct standard setting studies at that time. But yes, for the current phase of the practice analysis project for the California Bar, we are in the initial planning phases still, and in the literature review phases still, and working with this group to hash out some ideas and to get input on some basic elements of the study that we need to have decisions on so that we can proceed along those lines in the study.
Donna?
And in further response to Greg, one of the other things that we'll be wanting to talk with this group about either at this meeting or a coming meeting is thinking through ways that we might be able to partner with NCBE, which is going to be launching a new national practice analysis, and wanting to ensure, obviously, that the California attorneys don't get survey fatigue or confusion, and make sure that we are getting sort of the highest response we can. We might want to sort of consider opportunities for partnering with NCBE on the California survey. So that's something that we'll be discussing at some point in the discussions of this group.
Yes.
Emily Scivoletto from UCLA. Ron, I think you mentioned when we were talking about the previous bar exam studies that the content validation group indicated that they, and I don't know which group this was, but they directed sort of the state bar to essentially say that the NCBE from 2012 job analysis was not appropriate to help them with the content analysis, and that we needed a California specific one. So I'm wondering, out of that discussion, maybe that's incorrect, so correct me if I'm wrong, but out of that discussion, what did the group say was the problem? I mean, when we talk about California specific lawyers, why is the national study from 2012 not sufficient? And, you know, were there problems, obviously with the age of 2012, that may be true, but was there specifically as it relates to California specific?
One is certainly because the focus of this is from the focus of the NCBE 2012 study is national in scope, and there are some topics on the California bar exam that's California specific. So we weren't able to use the practice analysis results to evaluate specific the alignment on the California specific content that's covered on the exam. And all of these came from the recommendation of the report, not so much the panel making the recommendation. Another part of the limitation of the content validation study, as well as the standard setting, as Jackie mentioned, is we use the portion of the bar exam that's the written or essay and performance, not the MBE. And we have planned and discussed with the NCBE about the possibility in future evaluations for the California bar exam to actually have access to the MBE question items so that we can have a more comprehensive, full assessment of both portions of the California bar exam.
One last question, Bob. Brody.
Yeah, Robbie Brody here. I just wanted to follow up on Greg's question, and maybe Ron, you can make this clear to me. Is our group going to be telling or directing the vendor on who to poll in this survey? Are we going to be telling them all the new admittees in the last 2 years? Is that one of our purposes here, to tell them who to question?
That will be partly a survey design and sampling question. Methodologically, you want to make sure that the survey population is representative of the target population. So there are some technical considerations, but also certainly the consultant would hear the different views, and based on the deep knowledge of practice out there, we'll make sure that the selected sample has accurate representation of legal practices. One of the survey design is we'll certainly ask the practice area of the survey participant. I want to make sure whether the sampling strategy, we just randomly send it out so that the results is fair representation, or we want to stratify to oversample certain practice areas, for example, public interest. If that's an important element, then in the design of the sampling strategy, we want to make sure stratification is a consideration. So the interface between the technical consideration in sampling design and the practice area, this is where we would benefit from the working group to give us guidance.
I want to cut it off here. We were asking for some general questions, and I think we're going to get into the answers to some of the questions you've been raising in a little bit more detail in a little bit. So let me just come back and we now are going into item F on the agenda. We are obviously ahead of time. What I'd like to do is go ahead and have Ron present the agenda topic F, and then we'll see where we are. We might be able to do a little bit more before lunch, or maybe not, we'll see. But in any event, we'll take a quick break after this next item. Okay? Ron. I will come back.
So this is almost a continuation of your question about the sampling strategy. And here I'm just give you an overview about the survey methodology. Typically, practice analysis involves a survey where all of the domains and task statements are listed, as Josh mentioned. And then the survey participants will go through the list of the domain and task statements to rate on different scales, whether it's related to the importance of a certain task based on performance standards or some other dimensions. Also to get the idea of how frequently they perform those. So that's the standard traditional survey used in practice analysis. And it's, as listed here, it's a well-established method for conducting practice, but also it takes a lot of time to complete a long list of the task and knowledge domains listed, depending on the specific profession. NCB's had a survey that's fairly long, and based on our early assessment, we'll probably need 45 minutes to an hour for California for a similar kind of a traditional survey for survey participants to complete. So that's one of the disadvantages of the traditional survey. From the beginning, we thought about a different method, which relies on this idea of the survey participants to tell us at the time of getting a survey notification what they are doing at that moment. And this is either called random moment or experience sampling method. The random moment approach we use to conduct the BARS workload study. Traditionally, again, a workload study will involve people jotting down throughout the day what they were doing, how long different tasks take. And the random moment is getting the information about what they were doing at different moments. And the survey participants will get multiple notifications over a period of 1 week, 2 weeks, depending on the sample size that we need. And the results will tell us a very accurate picture of the frequency distribution of the different tasks performed, as well as the knowledge domain that's required to perform those tasks. So the advantage is every time you get a survey, you just tell us where you're doing and a few other follow-up questions. The survey questions is reduced. You don't have to go through a long list. But the disadvantage is since you have to be committed to participate in the survey that will last over a period of time and multiple survey notifications in a day, 2 or 3, depending on, again, on sampling considerations. Sometimes it's hard to keep people in the study for that long period of time. So experience sampling method often have to be faced with the issue of attrition over 1 week or 2 weeks. So that can be addressed somehow statistically to fill in the gap. But those are the considerations for us to consider. And the advantage of using both is we'll be able to cross-check the results to have a different level of the validity confirmation of the results. So in designing the survey questions, delineating a knowledge domain, the two sets have to be consistent using the same, so that later on getting the results from both, we'll be able to compare and validate each other. Give you a sense about the flow of the ESM survey. The survey participants, after they committed to participating in the survey, the first question will ask whether they, at that moment, or in reference to the time that they will see in the notification, they are engaged in some more activities. If not, that's the end of the survey. Based on workload study, you'll get 20-30% of the responses saying that they are not directly engaged. This would include lunch hour break, or actually not present. They can come back and tell us they were sick. So that percentage of the responses wouldn't be part of the actual data that we will look at. And following to the next step, if they say that they are actually engaged in work activity, we have to come out with categories of activity as filters for people to be able to get to the final item, which is task, the specific task. So following the activity type, then they select the task type, getting down to the detail level of a list of tasks that they are performing. Once they selected the task that they are performing, the following question is the specific knowledge domain that's required to perform those tasks. And related to the task and knowledge that they responded to in the survey will be a series of ratings that will be the same used in the traditional survey. That is to ask how important what you are doing is, how complex it is, or any other similar kind of a ratings that's typically used in practice analysis. So that's the some background about the survey, the two survey approaches we're going to use to conduct the validation survey. Okay. Any questions about this part?
Yes, sir.
Aaron Taylor from Access Lex. I'm very intrigued by ESM. This is the first I've heard of it. It sounds great, actually. I just have two questions. What other realms has this method been used, or I guess what's the basis for it being a rigorous way of getting the insight that we need? And then the second question goes to delivery. Is this something that will be delivered on a smartphone so they can really like instantaneously respond, or will it be delivered desktop, traditional way?
The idea behind it in terms of a random moment survey has been around for some time, 20, 30 years. Actually, it's used very commonly in federal government reimbursement programs. You fund a organization to do different things. A specific grant is related to just one particular project. And random moment survey is a way of just getting the resource allocation information. So anytime you get a ping, you tell the survey people what you are doing, and the result will give you a sense. For example, 30% of the time is devoted to doing things that's benefiting from this grant. But that's the approach the federal government in different agencies used to specifically provide reimbursement on different projects. The idea also, yeah.
So Ron, what is the proposed sampling size, if you know? And secondly, what is the timetable associated with the proposed sampling?
Okay, we'll get to that.
Okay.
Ron?
Yes.
Sorry, John Palmer from Laureate. I'm a little bit, I have no background on this, so my question's probably super basic. But my understanding is that we're going to come up with some larger form of this diagram, and then we're going to engage in experience sampling in order to try and validate this thing that we came up with. Mm-hmm. Is that right?
Yes.
So we are going to create a bunch of domains and tasks.
Right.
And then are the task types that are in your flowchart the task types that we've come up with?
Uh-huh.
Or is there some other way, some other kind of
Organizing
ontology
principle.
of
Yes,
types
right.
that we're going to use in that flow chart? Because if there are types, I don't think I understand how going through this validates this when this is built into that.
Okay.
Can I follow up on Aaron's
Sure,
question? So the two questions I have are pretty much the same, and I just want to make sure that I'm getting the answer. One is, there are other job analysis industries that have used ESM as part of the methodology. I just want to make sure, maybe that's a question for Josh. That's one question. And the second question is, when they get this ping, is it an email, is it on their smartphone, is it something so that they should be, are they engaged currently in that work activity? Or is it at the time that they got that email, what were they engaged in? Because those are two very different things, because obviously a lot of people in our industry check emails at a certain time, or so.
Mm-hmm. So the first question is size of this survey. Size, part of the package included discussion of consideration of size for the survey. And survey sample size, obviously, Donna mentioned we also need to coordinate with NCB, because if we fall on the same time frame to conduct the survey. But typically a sample size question could be easily determined based on statistical considerations. Of course, you also want to consider the strata, whether a certain practice area you want to oversample. The sample size consideration is a little more complicated for this ESM method than the traditional, because the responses come with one individual providing multiple responses. So all of those are considerations. But if we get 5,000, 10,000, that would be more than sufficient to answer a lot of the different levels of the questions. And the survey tool that we used, that we're going to use Qualtrics at the time signing the contract, I actually was targeting 40,000 responses. That just trying to get as much as possible. The typology of the questions, that's been getting to your question, John. Jim and the group, we had weekly meetings trying to tackle all of these issues. There are different ways of organizing the different types of activities. The panel later on that would create the question items will be where all of these questions will be determined. That is, what is the best organizing principle to have all of the items and domains organized so that when it's presented to the survey respondent, it's intuitive, it's logical, it fits into the flow of the everyday work. Currently, there are several proposed ideas, whether it's performance-based or some other kind of organizing principle, but it really is something that we'll be able to hash out during the panel meeting.
Josh, would you mind? I need somebody to talk to me like an idiot. Yeah, John Palmer from ARC. How does the experience sampling method validate this practice analysis?
Sure, this is Josh McKinnon. There's two right now validation plans. One is to have a traditional survey, right? And then there's the experience sampling method. So both will validate the survey based on the scales. One answer to your question is based on the scales that we're going to talk about later today. Things like how often someone performs a task, how critical the task is that they're performing. There's a number of scales that we're going to go through later today. So by gathering that data, we can then figure out, are the tasks and knowledge statements relevant? Is it something that someone's actually doing on their job? And B, how to weight that on the exam. So how many items on the exam need to go to that domain. So there's two answers to your question. One is, if it's not relevant, then maybe it's something that we need to remove from the exam. And the other side of it is weighting the actual amount of items on the exam devoted to each task.
Okay, I have one more follow-up, sorry. John Muller from ARC again. Why does the validation come after the creation of the practice analysis rather than taking the data from the survey and using that to inform the practice analysis?
To answer your question, you have to start somewhere. It would be if we had a survey that was kind of open-ended, what are you doing right now? It would be very difficult to piece it all back together. So we have to start somewhere. And that work of the panel creates something for us to validate. Otherwise, we'll get back a lot of different things and it would be very challenging to piece it all back together.
And the survey question will also be tested before we formally launch it. So there are several opportunities to comment on the completeness and the logical nature of the survey questions. Okay, Greg.
Greg Murphy, I'd just like to follow up on the Dean's question here, which was, how does the person respond immediately or at the end of the day? I mean, because I can envision circumstances where it's one thing to be in the midst of writing a brief and getting a question, what are you doing in writing a brief, as opposed to, well, I'm doing a deposition. That was one of your questions, I think, right?
Right.
How are they surveyed for the ESM, and what are the details? How is that conducted?
Okay. So getting all of these questions related to ESM, I'm pretty familiar with the kind of questions because this exact same method was used in conducting the workload study in the judicial branch that was done almost 10 years ago. So that the survey was sent out to staff in the court and as a way of conducting a workload study in comparison to also a traditional diary method. So there are different ways of handling. One is to, first of all, about the method that we use, email or texting by telephone. Both are possible based on the tool that we're going to use, Qualtrics. But we have to also consider whether one will pose some limitation to the survey respondents, whether email will be a better way so that everyone will have access when they actually check their email. In terms of the response time, in reference to the time that we want them to respond, which will be indicated in the survey notification. The survey results from the past, you would see most of the survey responses, they send it back within 30 minutes. There are some outliers. You could even send it back a day later if you haven't checked the email. But this notification will tell you clearly whatever response you give us is written in reference to the time that you received an email, if you remember.
Thank you.
Yes.
Neil Gupta from the Supreme Court. So just more about the mechanics of this notification. You mentioned either email or text. So what does the survey person see? A link? Do they click on the link and then they go onto a web page?
Right. Okay. Individualize the link, not only to the individual, but also the specific time in the reference.
Okay.
And I think one of the things, John Hirschquist, one of the things, John, that might help as well, if I can point people to the document in your materials that's entitled Validation Rating Scales. If
Yes.
you hadn't seen that sort of demonstrates that we've you know, in these panel sessions that we're going to be having, we've identified what we think are the tasks and the knowledge and the skills and abilities that might be required of an entry-level attorney. And part of the questions that they are asked when they get these pings or emails or texts, you know, we're looking at, when were you first expected to perform this task? Never. I don't do this. When did you? How important is this activity to your practice? It's not at all important. So that's how we're saying, okay, we thought that this could be a task or a knowledge, skill, or ability that you would need, but the results are telling us, not for entry-level attorneys. You don't need that. It's not something that you learn in law school. It's something you learn in your first year of practice, so it wouldn't need to be on a test. That kind of analysis will sort of, it is how that validation process works.
So you might be able to just reduce two key dimensions in the rating. One is the frequency, how often do you use it? The other is importance. The two have to be considered simultaneously. An example that's often used is police officer using guns. How often do you use it? Probably never, or rarely, unfortunately, for some. But then it's very critical for them to know how to use it. So it's something that definitely needs to be part of the testing for them in that situation. And we use the random moment, we'll be able to consider some additional dimensions that we think are relevant in assessing the content validation. So that's another advantage of using the random moment or experience sampling method.
Robbie Brody from LA. Just another quick mechanics question. Maybe Donna, you can answer this. So is the bar going to be providing the vendor with contact information for who we choose to be in the survey? If we want to send it to everyone who's passed the bar in the past 2 or 3 or 4 years, is the bar going to be providing email, telephone, contact information to this vendor of all of those people?
Yes. And in our coordination with NCBE to conduct their national scale survey, sharing that email list would also be part of the discussion.
I see.
Shanae Buffington, will this practice group determine the survey questions? Are we going to be given something and then we can review it and provide feedback, or how will it go?
Go ahead, Josh.
This is Josh. The panel that that is selected will create the domains and the tasks and things like that, which in a way will be survey questions because that's what we'll be rating. It's my understanding that we're going to discuss the different survey scales today, and that I'm not sure if this group or someone else will be making that final decision, but you will certainly have the opportunity to make recommendations, is my understanding. And maybe Jim can clarify that a little bit further.
Yeah, so the outline that is developed by the practice analysis panel in a few months will form the basis for the validation survey. And we'll ask participants in that survey, in the traditional survey, to look at the domain or task or subdomain and evaluate that statement using several scales. Typically, they are whether the newly licensed attorney is expected to perform that task, and then maybe the degree to which harmful consequences might result in the event that an attorney is not proficient, an entry-level attorney is not proficient in performing that task. That kind of scale that is used to validate the different elements of the outline in the traditional survey. In addition, there is a demographic part of the survey, and that demographic part allows us to know that we have input from people in the various practice settings that or practice areas of law as they are defined in California. In addition, to know that we have responses from people from small practices, large practices, different types of employers, that kind of information, so that we know that when we generalize from the ratings that we collect on the domains and subdomains and tasks, that we're doing so on a sound basis. So I hope that that's helpful information.
Thank you.
Yes.
Hi there, this is Sarah Cassidy. So looking over some of the domains and tasks that attorneys are being asked to self-analyze and consider whether they feel like their practice is reflective of these skills, was there any concern that maybe they're not the best persons to evaluate themselves, and whether or not supervisors should be or any other third party should be evaluating what skills are needed for an entry-level attorney and whether what they're doing is reflective of these skills?
This is Josh. Well, that's one reason why you typically want to have a panel that's representative of the population of attorneys. It's, you want folks that are new, and you want people that supervise as well. So hopefully you get a cross section of the industry for that very reason.
Sorry, Tom Palmer, I'm not sure that I understand your answer to her question. Because, sorry if I'm getting this wrong, but I thought her question was, are new attorneys able to evaluate, for example, the importance of the task that they're performing? Or should somebody else be asked how important the task is that they're performing? Because maybe they don't know.
And just to quickly add on to that, there are some studies that say that new attorneys tend to fall short in certain areas and they don't realize it. They rate themselves much higher in those areas than their supervisors would. And also what's expected of them is rated differently. So I'm just wondering if self-analysis is the most appropriate way, or if this should be, and this may be way out of scope for what you're trying to do right now, but whether a third party should be evaluating a new attorney or a third party should be evaluating any attorney on their ability to succeed on these tasks.
This is Josh McInnes. To answer both questions, I still go back to, I know there's a question about self-evaluation in there, which I don't know that I have a good answer for. Maybe Jim can chime in. But in terms of the other question of, to me, there's a question of breadth in there about, do new attorneys are they aware of what they need to know? And that, once again, is why you have a representative sample. Jim, maybe you can speak to the idea of self-evaluation.
So in terms of, I guess I don't understand the question. Are you asking if an attorney is able to tell us what he or she needs to know, or are you asking if the attorney can, in completing the survey, say what? I guess I just don't understand the question.
Sure. Okay. So my question is whether an individual can be honest enough with themselves, especially someone who hasn't been in practice very long, to understand A, what's expected, and B, whether they're achieving high marks in that area. Because if you don't fully understand the task, how can you assess whether what you're doing, you assume what you're doing is right, otherwise you would be doing it differently. So how are we reflective?
Yeah, so then the question boils down to, is the respondent in the survey able to understand what is being asked and apply the questions based on his or her practice in the way that we intend? And so, we are very experienced in constructing these surveys. We'll work with the practice analysis panel to make sure that the language that we use in the framework is clear. And then, part of what we're trying to do is to establish that the content framework applies universally for newly licensed attorneys. And so if they tell us that the task is not relevant to their practice, or that it is in some way not clear, then that's information that we'll take back to you as a group to help us understand and make decisions about. But we are going to be writing very clear instructions. We'll give, we're also surveying intelligent people. And so I believe that they will understand what we're asking and be able to apply the questions to their practice in a way that means that the data we collect are valid data. We also will be calculating the reliability statistics related to the data, and so that's an estimate of error in the ratings that we get, and will be useful in answering the question that you've just asked.
Can we maybe give some specific examples of questions? Because I think the theoretical nature of the conversation may be confusing.
I mean, if you just look at the validation rating scale, at what point did you acquire the knowledge needed to perform the domain or task? Somebody may say, my first week. If I'm supervising them, I may say they haven't acquired it yet. So I'm not sure that the self-report is really going to provide valuable data there. Similarly, how important is this activity to your practice? I and the person that I'm supervising may have wildly different answers to that question. What's the level of difficulty? Well, you may be thinking that it's easy, but you also may be screwing it up. Or what degree of harm may result if you don't do this, right? Again, that the answer to that question may vary substantially based on how big of a picture you see. So I'm not sure that if I ask an attorney who starts at my firm after passing the bar, these questions, that their answers are going to be of any value to me. If I'm really trying to get at what they need to know in order, not to commit malpractice. And I think it's worth harping on because it seems like this is fairly fundamental to our endeavor here. But if we're going to, ask people a bunch of questions that they're not in a position to be able to answer accurately,
So this is Jim Henderson. If I can just interject as I understand the question here. First of all, the page that you have where you have a draft scale that can be used in a study like this, the decision about which scales to use has not yet been made. That's a big discussion item for this afternoon. And so we'll be getting some direction from the discussion about which scales seem to give the best information. But then the question about whether the respondent himself or herself is in a position to judge the way that the task or subdomain pertains to him or her. There are two components of that answer. First is that what they are being asked to evaluate, the task that they're being asked to evaluate, they should be able to read that task and know that they have performed it, or whether that is something that they have never performed. And they should be able to apply the scales in some reasonable way to their own experience in practice. And if we are asking questions about their training, they'll know whether they learned it in law school or whether they learned it in some other setting. So I think that once we have selected this, part of the decision that goes into the selection of scales is whether the respondents will be able to provide a good answer using their own experience as they select responses for those scales. The other thing is that we're going to be collecting data from a large sample of people. And so if there are a small number of people who are giving responses that they're not, able because of their limited experience to make an assessment on, then that's going to be overridden by the large number of people who do understand how that task or subdomain applies to their work. One of the advantages of surveying a large sample, we're not going to make an assessment about any individual's practice. We're looking at the broad practice of law for people who are newly licensed.
Yeah, so this is Neil Gupta from the Supreme Court. So just to sort of follow up on John and Sarah's questions and your response, Jim. So in terms of the selection criteria for what I'm calling the newbie lawyers, okay? So obviously when any new attorney takes the bar exam, say starts at a law firm, there's just a whole bunch of stuff that person has to learn, administrative stuff, personal politics, to get up to speed, to even just understand those dynamics, and let alone sort of learning the skills that you need to be a lawyer at a law firm. So I noticed here that in some of these scales, like point of acquisition, talks about the first 6 months of practice. So obviously, I'm assuming that that the selection criteria is going to look at newbie lawyers that are X amount of time have been practicing. Is that correct?
Yes.
Okay, and so what's the X amount? And maybe this group can give input about what that X should be. Should it be 2 years? Should we call it, are we sampling? Because if there's a concern that a newbie lawyer in the first 6 months may not give reliable answers to some of these questions, then maybe we need to discuss what the X should be.
Maybe I should clarify. The focus of newly licensed attorney is only a subset of the overall survey response. We're going to go beyond just the newly licensed attorney. So the population of survey respondent will include newly licensed, just the 6 months, 2 years, 5 years, 10 years. And the results we'll get obviously will vary. And that variation will tell us on the reasons for that variation, whether demographic, practice area, practice setting. So it's not a sample we're going to send out only to the new attorneys.
Got it, okay.
All right. It is now 10 of 12. We have a scheduled lunch beginning at 12. The box lunches are here in the back of the room, so we can start now. Why don't we stay on schedule and come back at 12:30? Do you, Josh, how long do you think your presentation on the next discussion item is? You have 45 minutes. Is that about what you need?
I envision it being more of a discussion than a presentation. I believe that's Jim's thoughts as well. Is that correct?
Yes.
Okay, well, let me amend that then. Let's take our break now for lunch and come back at 12:20. That gives us 30 minutes, and maybe we can, if we end up with a longer discussion or any of these remaining items take longer, we'll still be able to be out by 3.
We also have Stephen, who came in late, to introduce yourself.
Oh yeah, my apologies. I had to finish up a board call this morning. I'm Stephen Farrell. I'm the Dean of the University of San Diego School of Law, and thank you for having me as a member of this working group.
Thank you. All right. We stand in recess.
You know, you had 5, for Josh's last slide, you had 5 different parts of the process. This one is in that middle. These are patterns to provide information.
Jim Henderson
has left the con.
The California Attorneys Practice Analysis Study Working Group is now resuming after our luncheon break. It's 12:20. The morning session was, to me, very interesting. Good presentations, a lot of good questions, but I was left with a fundamental question. Why am I here? And what are we doing, and what is our role? So I thought maybe it would behoove us just to take a couple of minutes and return to the 50,000-foot level and ask Josh and Ron to give us a little bit, or at least me, probably the only person in the room who isn't sure about this, but at least give me a better idea of where this group fits in and what you are going to be looking for us to do and what we can kind of expect before we get into the further discussions of the structure and so forth. Okay? Thanks.
All right, this is Josh. Just wanted to back up for a moment and revisit two things. One, the baking example that I started, and this slide of the process. So ultimately, we are trying to get to this part where we have domains and tasks and knowledge statements. And to provide a little bit better example than I did before, if we had a baking exam, and we might have a domain for baking pastries, if our panel of experts felt that that was a major area. If our panel of once our panel of experts decided what the domains were going to be, then we would start looking at task statements. So for instance, we might have a task of cracking eggs. We might have a task that's mixing ingredients. We might have a task that's rolling dough or something along those lines. Once the panel hashed out the domains and the tasks, we would look at the knowledge statement. So what critical knowledge does it take to do those tasks that fall underneath those domains? So we might need something like the knowledge of what ingredients go together, or how to use a mixer, or how to operate an oven, or something in that realm. So jumping forward to my last slide, to put that in perspective, we're talking about this middle bullet that you see. Delineate domains, tasks, or subdomains, and knowledge and skill statements. So that's what the panel is going to do. There are...
This panel plus or something?
Well, and that's a good question. The question was about which panel. And I felt like there was a little bit of confusion there. So this panel, the goal here is to put input into all the things that are listed here in this final bullet. So, the target audience statement, the eligibility requirements, putting input into the panel that will ultimately make the decisions of delineating the domains and the tasks and the knowledge.
Josh, let me ask you something. You mentioned an expert panel.
Mm-hmm.
That's not this panel, right, or this group. Are we the expert that you're looking for?
Well,
God forbid.
It's my understanding, and Ron and Jim, you can certainly chime in here. It's my understanding that this panel, the purpose of this panel is to inform all the decisions that will be made that you see here. That some of the same decisions that we were getting earlier about what survey rating scales to use and who to sample and all those things. Those are decisions that this group will be making, as well as choosing, at least to some degree, who sits on that panel of SMEs that delineates the domains, tasks, and knowledge statements.
Eli?
I also want to let everybody know that also in the packet is a project timeline, and also just further delineate between the working group and the panel. The panel is expected to be held in February, and it's an extra panel of about hopefully 12 to 15 people that can include working group members based on volunteer. We're asking them to volunteer 3 days, but it doesn't necessarily, working group members are not necessarily going to be on the panel. And we are also going to have a section this afternoon to discuss recommendations of people who should be on the panel. In the panel, the working group is the guiding advisory committee, where we're going to discuss in an hour about what we're going to show to panel members. But the panel is ultimately going to be the one coming down and defining the tasks and domain statements that are going to be in the survey.
We're not. Emily, UCLA. So this working group is not going to do number 3, delineate domains, tasks, subdomains, knowledge, and skill statements. That will be the panel you just spoke of, Eli?
That's correct.
Okay.
Immediately after this first working group meeting, the task is to convene that panel. And currently with the timeline for holding that panel meeting, the 3-day panel meeting sometime in February.
So based on this timeline, is this our only meeting?
No. We'll meet every 2 months or so. The purpose is to assess the work product at different points and provide feedback. And the next milestone is to convene that panel meeting, and the deliverable from that panel meeting is a first draft of the domain statements, task statements as the basis for creating the survey questions.
And we're going to discuss future working group meeting dates at the end of this meeting to find dates that will be suitable to the people here today. And then we'll send an updated timeline as well.
Right. Okay, so we're not going to do the third thing. But I do want to contribute something in the sense that I talked to Mr. D. or I sent him. There's a uniform task management system that the ABA developed, which is basically everything that lawyers bill for. I mean, from conferences with clients to take depositions to answering interrogatories to, and not just litigation. It's non-litigation stuff. And the reason I mention this thing is I'm involved in a project with the NCB one where we spend nearly a whole day trying to, with a group of lawyers, experts, developing our own list, and then it occurred to me about 2/3 of the way through that had already been done. So, make sure your group that does number 3 is aware of that system, because it'll save you a lot of time and effort. It's not the answer to everything, I'm just saying.
Right.
Okay.
Josh. Now, this is Josh. Now having said that, there are a number of topics related to that process that we need to discuss today, and that this group is going to inform. Jim, did you have anything else that
Margie
you would like to
Estrada,
add?
as a public participant today, has joined the conference.
Welcome, Margie.
Hi, thank you. I am so sorry. I'm on another task force of the State Bar that's going at exactly the same time, so I'm not going to be able to participate except during our short break. So I apologize. I will be at the next meeting.
Well, we hope so too. Just to orient you, we are just returning from our luncheon break, and we've just had a kind of a step back, quick discussion about the role of the people on this committee and where we will come in, a working group, and where we will come in. And now I think we're about to go to agenda topic H, which is a discussion led by Joshua McGinnis and Jim Henderson. So,
thank you.
Josh.
Jim, are you on the line? I asked a question if you had anything else to add before we moved forward.
I am on the line, and so my understanding is that this group really serves to provide oversight or supervision, if you will, for the conduct of the study. The detailed content of the study is to be developed and not by this group. This group will have a chance to review it and determine, a sense of its clarity and adequacy, but it will not be responsible for developing it.
Thank you, Jim. I know Jim put together this agenda initially, and I just wanted to make sure that we're kind of adhering to the ideas that he had here. agenda item 1 under H is organizing principles for classification of knowledge domains and skills for surveys. Jim, what did you specifically want to discuss here? Was this within the instruction booklet?
Sure.
The
Yes,
domains?
it's reference to the instruction booklet and definitions of domains and tasks. And so there are two basic ways that I think it makes sense for us to proceed in developing with the panel that will meet, in early 2019. The domains and more specific elements of a content framework. One is performance-oriented, and the other is content or topically oriented. And so the difference is that a performance orientation is going to have activities described in both the domain level and the task level, such that, much like Josh's example about baking, if we were doing a practice analysis for bakers, then it would be selection of recipes. It would be as one domain, and it might be determining or selecting the standards for the ingredients that would go into whatever is being baked. Those things are things that are areas that would be areas of responsibility. That is in some contrast to a topically organized system. The topic orientation would be one that's based on, different elements of the law. And so in the instruction booklet, on page 6 is a set of performance domains at the top, in the top third of the page, and in the middle third of the page would be some topic or organizational categories as examples.
Page 7. It's page 7 in the material you have in front of you.
I'm sorry. And so the performance-oriented ones would be steps that attorneys follow in their service to the public. And I have made up some here. I'm not an attorney, but my guess is that at the beginning of a case or some other activity with a client that the attorney engages in some planning and probably some research, and then implementing that plan, assessing the progress of that plan against the objectives, and then there's also the element of practice management and professional responsibility. In contrast, a topical organization would be organized around different aspects of law, such as civil procedure, constitutional law, and I realize that there are many other topics that could be listed here as domain. So we're talking about here with domains, the big buckets into which the content details would be organized after these buckets are determined. So for a topically organized outline, instead of if then we use things like civil procedure and constitutional law, then the subdomains would be more specific topics within those larger topics. And I've just given a sampling of those that I believe are at a reasonable level of generality or that would correspond to the definition of what a subdomain is. A task statement, though, is what would be used if we followed the performance domain organization. That is, examples of those are in the top half of page 8. And so that's, examples that are at the level of generality that I have in mind for this. Gather information about the client's needs and expectations, consult with sources of expertise by identifying qualified individuals, so on. You can see what we've got there. And so the question that I would like to ask the group at this time is, what makes more sense to you? Now, regardless of the way we go, if we follow the performance orientation with performance domains and tasks, we're going to be developing and also with the topic orientation as well, we're going to be developing a list of specific knowledge statements that the newly licensed attorney would be expected to know or to possess in order to provide proficient service to the public. So if we follow the performance domain and task organization, the advantage is that it ties the content to very directly to the practice of law, the things that an attorney does. But we certainly want to test the law, and I'm more interested, I think, in testing their understanding of law than I am of their understanding of techniques for conducting an interview, for example. So the question to this group is, which basic structure makes more sense? Or do we like a performance orientation, or do we prefer a content?
This is Margie Estrada. Does it have to be one or the other? Can we look at both?
Yes, we can do both.
I mean, I believe that it's important to, the content's important. Students should absolutely, know the law, etc. But performance is also key to being a successful attorney.
This is Ron Horrible. Should there be a distinction, not so much about which orientation we use, but where we start? Because at the end, there has to be some linkage between performance of tasks and knowledge domains. So
I'm sorry, I can't hear one word that's being said. Can someone go closer to the microphone?
Sorry. So I was trying to make a distinction about whether we want to go with one or the other, but rather it's a question of where we start imposing the questions. For example, if we start with performance-oriented organization, then the survey respondent will tell us what they are doing, and then the follow-up question will be the knowledge domain required. So it's more a survey design issue, because at the end we have to make the linkage between performance of the task and knowledge required. So yes, it is correct that we'll ask both, but it's a question of what's the best way of posing the question so that people will find it, the organization is logical and intuitive, but also reflects the day-to-day routine of the work.
This is Ron. Can you, or Josh, or Jim, can you give us an example of how the questions would be framed in the task statement, if we organize it by performance domains, or we organize it by content domains? I don't think the group has enough information to know which way we should go yet.
Eli?
Eli Wallach. I would just present a hypothetical or imagine yourself in the field, and also remember that there's going to be two different subsamples of what we're looking at. One's going to be a traditional survey, where they're going to fill out a survey that might take 30 minutes to 45 minutes, reviewing their memory of what they were working on, and one is going to be a ping. Now, if you get a survey and you start answering questions, the difference is going to be whether or not you're talking about so whether or not we're talking about content, which would be you're looking at criminal law or civil procedure, or sort of the content frameworks that we're going to come up with, but are more in line with the content divisions that you already see in the bar exam of what's tested in the content division, versus as some of the performance ones are more writing a memo or writing or in a meeting with a client, sending an email internally, doing more things more oriented towards the task, and then there could be a question afterwards that asks about which field of law it's within or which content domain it's in. So that's sort of the difference, that the content would start with either which field you're in and then go into the task, or start with the task and then go into the content. I hope that's helpful and clarifying.
Could I, Stephen Perillo, could I just comment? From my point of view, it has to start with performance, because the reality is that law is more and more practiced on a specialized basis. And I speak from my 20 years in practice in California as well as my years as dean. Okay, so what we have in common in lawyers in terms of what we do are the things that are listed here under the performance domains. Every lawyer does those things. I was a transactional attorney. Okay, from the day I started practice in California as a transactional attorney. Civil procedure, constitutional law, and criminal law and procedure completely irrelevant to anything that I did as an attorney. Okay? And you pick your specialization. Is it tax? Is it intellectual property? Is it immigration? Is it that's what we're dealing with in California. When I started practice in California in 1990, in big law firms, there were still rotations. Right now, you're hired into a big law firm, you specialize from day one. You're assigned to a group, and even in transactional, you're doing specific type of transactional work. It's the same I hear in things like city attorney's office and district attorney's office. Law is becoming more and more specialized. But there are certain things that all lawyers have to do. And I think that's where we should begin, because those are the common skills, okay, of providing legal services and legal analysis that all lawyers have to do, regardless of what kind of law they're practicing and who their clients are.
Right. Just returning to the 50,000 foot level, you know, we have an educational system that basically teaches the domains that are listed on page 7 and others, right? The knowledge there. While there's been a renewed emphasis on trying to develop more opportunities for clinical education, that's not where the heart of law schools are, and it's also the most expensive kind of education, so I don't know that that's where it's going to go. The problem is when you graduate from law school, you've got a pretty good basket of information about the rules of law and procedure and the like, but the actual practicing law and performance tasks, one does not receive much training in law school.
Has joined the conference.
In medicine, of course, one goes through 2 years of residency before one actually gets out and under supervised. If you're lucky to go to Oregon, you've got somebody like John supervising you. You know, we graduate people from law school without that skill set very well developed that you say, gee, you know, I'd send my Aunt Mabel. Now, there's some people I would send to, but there are plenty that I wouldn't send my Aunt Mabel to. Whether we can develop a testing system that, which is more than performance issues, sort of, how can we test on performance information, material that where they haven't even had an opportunity to perform out of law school? I think that's a critical issue. And that's why I mean, if there are testing methodologies to test whether someone's going to be good at interviewing a client or one of the other transactional things, great. I think that the difficulty is that testing regime is probably very, very expensive.
Well, next to again, Steve Perillo, legal education has changed a lot in the last 20 years. The first thing that our first year students do in a practicum we have first semesters, they interview a client. So we are doing it in clinics, we're doing it in experiential, because that's what employers are demanding.
And if we're not doing that in law schools, then we're really failing, because if you look at the criteria for hiring lawyers these days, it's experience and expertise above anything else. And so law schools have been doing that. And so we're glad to be having our students tested on that, rather than being tested on 14 subjects across a broad range, most of which are completely irrelevant to anything that they will ever do.
So I appreciate the merits of both of these arguments, both of which have some validity, but as Ron formulates it, is how you set out the survey in terms of the format, and then all this information is going to be gleaned somewhere. So the question, in my mind, is the practical one, and that is, what's going to be the least likely to dissuade somebody from responding to the survey? And when I look at these domains, if you present a young graduate with issues of planning, implementation, assessment versus what they've been learning for the last 3 or 4 years, civil procedure, con law, contracts, I think just in terms of the survey, it's much easier to approach it the way they've been taught to learn, as opposed to the way the dean articulates it, which has some validity in terms of what they're actually doing, but it might not be the best way to set out a survey.
Yes.
So, a couple things. One is that I appreciate Margie's idea about both, and so if there's a way, but then I also understand now from Eli, just so I'm understanding that the questions are going to go to somebody, and it's going to ask them from the domain to the task, and then the knowledge and skills statements will relate. Let's say we start with performance, but that we would also eventually in that survey get to what they are working on as it relates to a subject matter, right? Is that correct? So we will get at both, but it's really kind of, we're talking about how we might organize the survey and start with it. Is that correct?
So this is Jim Henderson. If I can jump in and just offer that from my perspective, the decision on this is based, that is your judgment on this is better based on what makes for the optimal content framework for the examination than anything related to the design of the survey. Certainly with the experience sampling method, it's a selection of the activity that the respondent is doing at the time. That's very straightforward, but it could also be that they would say, I was using contract law at that time, or I was and I was working on some rights in real property at that time. So I feel like the most important consideration in this conversation is what's going to make the best framework for the examination.
Okay, so I guess then my other question, this is Emily again from UCLA. Hey, my other question that I have is two things. One is, how does there's literature out there now that talks about what lawyer competencies are and what law student competencies are that don't relate to knowing, sort of specifically, what the mailbox rule is for contracts, but relates more to fact-finding and practical judgment and researching and analysis and reasoning. Those are the things that I think that we should be testing. And again, I don't have an idea of how to do that. And I think the reason that we are going the other way and test civil procedure, con law, et cetera, is because the law school tail is wagging the dog, essentially, that, we want to prepare our students for the exam. So we have these required classes that fit to the bar exam, and that's why we've continued to do it. But as Dean Furlow says, we are changing. If we go down this road, we're going to see a lot of people in California, when you get to the end of that, saying, I was working on IP, I was working on entertainment law, I was working on immigration. It has nothing to do with these large, big, broad subjects. So that is to say, as we're designing, Jim, and as you're talking about us designing an examination, I think that this test the ability, and I think I'm speaking somewhat to the choir here, but test the ability to memorize rules and put them out, but it doesn't necessarily get at those types of things that I think a literature review would say, which is, again, the fact finding and all of that. That is not, we don't just have to have on the performance test side. That is not to say we have to throw out essays and not ever test on civil procedure or any of the content-based or subjects. But it is to say testing in a different way so that maybe some of the skills that are being tested are utilized more so in a performance way than just, again, sort of regurgitating subject matter.
One more question, and then let's move on to the other parts of this presentation, okay?
Just a comment building off the previous comments in that, this is a study of the broad practice of law in California. And I guess the primary question for me is what are the ties that bind the broad practice of law? And those ties are the skills, being able to engage in advocacy, being able to identify and analyze legal issues. Those bind the entire profession. Does it matter that a transactional lawyer doesn't know the intricacies of criminal procedure? Will we deem that person unfit to practice law in the area that they practice? Probably not. But does it matter that a transactional lawyer can't engage in any form of advocacy or is not good at identifying legal issues? Yeah, we probably would deem that person unfit as we would deem the criminal lawyer who can't do that unfit. So I think the skills piece is probably the best framework from which to build. And then, of course, we don't have to throw out the substance, but the tie that binds all of these people, all of these professionals, are the skills and abilities that they must use.
Okay, so let's go on to the rest of the discussion here. Josh and Jim.
Sure. All these things that I'm hearing, they all do tie in to where we're going. And the next topic on our list is minimal competence, which is someone that has that level of knowledge, which is really a continuum from those that don't know enough to pass the exam to those that are going to pass very easily. And it's finding that sweet spot there of what knowledge must a new attorney actually know. So I don't think that I think this all does tie in.
So I think that it seems to me like what I've been hearing are various ways of saying that there's not maybe, or it's going to be very difficult to find somebody who graduates from law school and is competent, even minimally, to sort of practice law in the broadest sense. Like that they could go out and be a criminal defense attorney, or they could go out and be a transactional attorney, or they could go out and be an IP attorney or an entertainment law attorney. And that just the concept of minimal competence to be a generalist lawyer upon graduation from law school might be a thing that doesn't exist, like the Easter Bunny or Santa Claus. And if that's the case, which I think that there's an argument for it being the case, then there's sort of a bigger question which may be beyond our scope, which is what are we doing with the bar exam? Because if you're testing a bunch of skills that you need to have, those are necessary conditions, but I would argue are not necessarily sufficient to be a minimally competent practicing attorney. So, and I think it's for you guys to, focus us in terms of scope and see that's either inside or outside of our purview. But it seems like that's been banging around a little bit.
Go ahead, Reza.
I just want to caution, if I might, Judge Mayfield and I, we come from rural, not urban communities, where there is such a thing as a generalist, and not everyone's a specialist, and there are general practitioners who are the heart and soul of communities. So it's not obsolete, even though that's the current status in our large cities.
Thank you. Okay.
All right. One second. I just want to say, add one more thing, and just sort of reiterate that in the survey, and to really think about not necessarily about the how the test is going to play out, because right now we're focusing on how we're going to distribute the study and do the study, and how we're going to distribute the survey. But think about the question. The first, as you guys saw in the diagram before, the survey kind of is like a funnel where you have broader and it goes more and more specific. And so think about at the top of the funnel, is it going to be content or performance? And then once, for example, if you had performance, you could say, oh, I was sending an email, the email was to a client, and then there could be a follow-up question about which general field it's in. So it could be about contract or IP. But those are sort of the ways that you can integrate both of them together. Or you can say I was working on IP, and then I was saying I was working on communicating with the client. You know, just flip like that.
Okay, Josh?
Yeah, Eli's going to pass out some thing that you're missing in your folders, which is some research that Jim did on some existing legal exams. So just so you can get an idea of that kind of organizing structure or framework.
This is Margie. It's Margie. Is it possible to get that emailed to me so I can look at it, or is it available online?
I want to be able to email it. My email's not working on my computer, so. Or could you attempt to help me? Yes, I can email it to you, Marty. Yes.
Thanks. The answer is yes. Okay. So yeah, this all kind of comes under the umbrella of our third topic, which was breadth and depth of exam topics. So if we are looking at a broad exam, then we have to think about what is the best way to approach organizing what's on the test. Jim, do you want to speak to that at all?
I think it's all part and parcel of the same conversation about whether we want a performance orientation or a topical organization. However, the different, there needs to be some consistency in the outline, in the scope that the different elements of the outline convey. If, say, we have a very narrow topic and a very broad topic, then why isn't that narrow topic a subtopic of a different broad area? So I'd like to hear some conversation about the types of topics. Now, we certainly, I heard on the earlier conversation is that, I've heard two things. One is that we don't need to restrict ourselves to a performance or topical organization. And then I also heard that a performance orientation in the outline makes the most sense. So it's difficult for me to ask this question about topics if we're going strictly with a performance orientation. So I'd just like to hear some reaction to this. Looking at on page 7, the performance-oriented domains at the top of the page and the topical organization structure in the middle of the page. For the examples that I've given there, are the different elements roughly equal in size? And if they aren't, is it appropriate and do they still qualify as major areas of the outline, the Roman numeral level of the outline, if you will?
Bob? Right. I gotta return to that, sort of different take on this. This is about the performance versus the topic. And I understand the desire to go to performance. But if you look at, for example, the first-year curriculum at the University of San Diego Law School, they have 1 credit experimental advocacy part practicum, 4 credits contracts, 4 credits criminal law, 4 credits property, 4 credits torts, 2 credits legal writing research, 4 credits civil procedure, and 4 credits constitutional law. Now that is the basic canon, and one of the reasons those topics appear on the bar exam is because it's been long thought that the basic legal principles are embodied in those various topics. So we don't see antitrust, and we probably don't want to put antitrust on the bar exam, or bankruptcy, all areas where specialty lawyers may actually go in and specialize once they begin practice. But we give general license, so unless we go to a whole new regime where we would just, we're going to test on specialties, which I suppose is Supreme Court could order. But keep in mind that we have a very large legal education structure that's not likely to change on a dime. It would certainly change if the bar exam changes to that kind of method. But in terms of practicum, and I suspect in the second, third year there's opportunities for clinical education at the University of San Diego. But the meat of the education that students receive are in these topic domains. And testing, surveying on performance, people who are relatively new to practice, relatively new, and what's important, it seems to me, is not going to be a productive focus.
If I could just speak, Stephen Perrella, the value of that first-year curriculum and the foundation of law school is not those specific subjects. Those subjects are a means to teach people how to think like a lawyer, to apply law to facts, to do legal analysis. That's what we need to be testing, not arcane rules that go back to those things, like the rule against perpetuities, okay? So I've questioned I was an educator before I went to law school. I taught for 10 years, including at Stanford as a professor of history. So I think a lot about what we're trying to achieve in education. And I've asked the question, why do we continue to teach law the way it's been taught since the 19th century in terms of that foundation? Because it works, not in terms of delivering a specific set of subjects, but in terms of laying the foundations of the kind of skills that any lawyer needs. I did global biotech transactions at the highest level. I learned those skills in my first year of law school in those courses, those analytical skills as a lawyer. And I think that's what we can say. But to go back and say we teach those subjects, so therefore we should test those subjects, I think that's the wrong assumption to draw. Because by the time people graduate law school, they should have moved well beyond those subjects and to develop expertise in the areas where they're going to be teaching. And to the point about people teaching, where people practicing and going, first of all, I think it is unconscionable of us in law schools to tell people in the current day and age you can go out there and practice law generally. I tell students that. I think that is malpractice. Okay, I don't think that is possible. But number two, okay, look at these subjects, civil procedure, constitutional contracts. Any rule, any regulation is right here. Whether I'm in Silicon Valley or Fresno, it's all right here. I can look it up. Rule 23 is federal civil procedure, or whatever the latest rule is under the securities law, whatever it might be, it's all right here. What I can't find here are how do I plan? How do I implement the needs of my clients? How do I, and things like that, okay? So if we send people out with all the knowledge they can get right here, but with none of the skills that they can't get right here, then we're failing our populations. And I think that's what we're doing. Because what we're doing is we're testing people on things that they can get right here. We're having to memorize them, rather than testing them on the skills that they need to serve the population of this state.
Sinead Buffington. So are we proposing to make the bar exam an open book exam, or I understand what you...
I would say that it should be less memorization and more talking about what we're talking about, which is basically applying the skills that lawyers need to be successful.
But can I just, I don't think our goal today is to figure out like how we're gonna take the bar exam. I think our goal here today is to determine what is that skill set. I mean, you referred to it, everybody at some point today has referred to the idea or the notion that there's a certain set of skills that are required. So let's say it's not memorization. Let's say it's not, we've heard more of what it isn't than what it should be. And I think that's what we're trying to gather. And I think at this point, the discussion's about the method for attaining that. But I think we also have to just come to an agreement that what we're trying to figure out is what is that skill set? I mean, that's this entire task. And so how do we achieve that? I think at this point, we've been talking about organizing this, whether it's performance, whether it's topical. I don't want to jump the gun and talk about the bar exam until we figure out how to strategize and assess what is this minimal skill set that's required to become an effective attorney or to function as an effective attorney.
Can I just
Okay, go ahead, Emily.
respond to Amy?
And then.
So I agree. I think we need to definitely talk about what the skills are that we're talking about. And I have a list because I've done some literature review. I don't have to deliver that. I mean, I'm assuming that's going to get done in some way, right? I mean, we're talking not too much, but analysis and fact-finding and, you know, practical judgment and sort of the things that we would agree do not necessarily attach it themselves to a specific subject area. I think you can still test subject areas and test these things as well. So I agree, you know, I don't remember who it was, maybe Jim, it was you saying we have to sort of think of this in terms of getting to the examination. So
Right.
I'm trying to do that, but I'm also hearing, actually, don't worry about the examination, we're just talking about the survey. So whichever sort of frame we're on, I think the survey should start with performance and get to law. I think the exam probably eventually, understandably, will have some law in it, because, you know, we will probably stick with that. But I think that there are ways for us to test these other things that may be a different way than we've ever seen before. And I really feel like we should be open to that. And, you know, if we're talking, and I agree with Dean Ferula, if we have 14 subjects on the bar that are all testing rules you can find on your phone, but they are also testing fact-finding and analysis, why do we need to do 14 subjects? Why not just say we're going to test, you know, 4 subjects and these hypos or whatever, and the rest we're going to test in different ways. So I would say that if you guys, and I need a little more guidance, maybe Josh and Eli or Ron or whoever, but if we are in fact trying to, at this point, I noticed that we skipped over minimum competency definition, and I'm hoping that we'll get back to that. But if we're just talking about the breadth and depth of exam topics, if that's where we're supposed to go, I don't feel qualified or competent to be able to do that until we know if we are in fact, I think Jim, as you said, answering the question, are we doing performance, are we doing topic, and if we are doing performance, as Amy said, what are those skills? Like what would we really be testing?
So just to sort of follow up on, this is Neil, to follow up on what Emily just discussed a little bit. So the way I sort of see this is that, say you take the example of somebody trying to litigate a summary judgment motion, right? And the skills required for that, okay? You know, you need to meet with your client, you need to gather the evidence, you need to be able to put together the legal arguments, put together the summary judgment motion, right? Be prepared to litigate it, all those things, right? Those are all a set of skills, right? That are important to being somebody who's litigating a summary judgment motion. But you can't really meaningfully talk about that unless there's a topic, right? And you can't even test those skills unless there's a topic through which, you know, if it's a contract dispute, then it's contract law that's the subject of the summary judgment motion. So the way I see it is that the performance does come first, but the topic is the way you figure out whether the performance criteria are being carried out and what they are. So that's sort of how I see it.
And to echo what you're saying, ultimately, we're talking about the framework or the organization of the content areas on the test. Once you drill down to knowledge, there is still going to be that legal knowledge. It's just going to be farther down the list. So it instead of having a section on one particular topic, it may be sprinkled throughout. there are good and bad sides to that. It can be, there can be a bit of a challenge in spreading it across the board like that. But I just want you to know we're focusing on the organizing framework, not the test questions themselves necessarily. Now, if you went really far in a performance setting, you get away from the ability to use certain item types. But I don't think that's what we're discussing here.
So, I mean, my understanding was not just the stuff on the bar exam was tested, because that's sort of where law came from, but also that those are the sort of fundamental areas that if you do graduate law school and you hang a shingle, you're going to be likely asked about, right? Wills and trusts, property, crim procedure. Nobody's going to ask you to litigate an antitrust case for you because you don't know anything. But for the guy, in Mendocino County or whatever, who is sort of a generalist, the stuff on the bar is the basic stuff I think that you need to know that's going to show up in court kind of on the most regular basis. But that, this just sort of goes back to and I know a lot of folks who are generalists, and I'm always awed because I have no idea how they got there and how they seem to be, fairly knowledgeable and competent in like 17 different areas of law, and I feel like I can barely get my arms around one. But I do think that it goes back to, what are we testing for, right? Are we, and is the idea of the minimally competent lawyer the guy who can show up and be a generalist in a rural county? And if you can sort of do that, then you're sort of qualified to do all the other things that you can do with your law degree. I mean, is that sort of where we're targeted? Except I think that if it is, that gives us a clearer basis for what we need to be asking and assessing than if we're just sort of looking at everybody who has a law degree who goes up to practice. But if that guy is the minimally competent lawyer, then I feel like we have a place to start.
Jackie?
So I'm going to take advantage of the pause for just a second. This is Jim, to say that this is twice I've heard a reference back to the discussion on the minimum competence definition. And so for that, I'd like to point everybody to, and I'm not sure because it looks like the page numbering in my copy that I'm using here in North Carolina is a little different from the way it is in yours, but it's the target audience statement and the definition of attorney that is either, I think it's probably going to be on page 6 of yours.
It's on page 6 in our documentation, Jim. It was reprinted.
I'm not quite sure what caused the difference in numbering here, but so there is the definition of what an attorney is there, and relative to this conversation around minimum competence and generalist versus specialist and these other very valid considerations that you're talking about, a newly licensed attorney has to be this, and is not going to be supervised in doing this. So I think that it is an important orientation to the conversation that an attorney is someone who practices law and do it without supervision. So I'll point this definition out, and then also it's followed by what you all already know, the ways that a person can meet the requirements to become eligible to take the test. And so those are listed there as 5 bullet points. And the way to think about that is to consider that if a person has just done the minimum amount to qualify for the test, that person has had reasonable opportunity to gain proficiency at the level that is required for the license. Reasonable opportunity doesn't mean that it's going to happen for everybody. And also, by completing 4 years of a State Bar registered fixed facility law school, there will be people who have gained proficiency at a far higher level than we're going to require for licensure. But think of these different routes to qualification as opportunity to have gained proficiency at the level that is required for licensure. So the definition of attorney and those things, I think, are important to keep in mind as we, talk about the different aspects of the content framework.
Okay, Jackie.
Yeah, thank you, Jackie Gardina. I really appreciate the conversation because I think it's a very helpful orientation. I just want to follow up on something Neil said about skills but needing to be taught through a particular subject area, which is, of course, something that would need to be done. And this is probably getting too much in the weeds, but I think it has to do with how we weight the knowledge versus the skill in the grading. Right now, the grading is focused on knowledge and skills as it relates to being able to articulate your knowledge in an organized fashion. But it's not focused on necessarily a skill development type question that undergirds a particular subject. So I would, right now I'm accredited through the State Bar of California, and the State Bar of California has a regulation that says I have to teach every subject taught on the California Bar. It does not say that I need to make sure that all of my graduates have a particular skill set that every attorney needs upon graduation. So I would love it if that got turned on its head, and instead of focusing on here's the 14 subjects or 16 subjects your students have to teach, that instead what I was told is here are the skills that every competent attorney needs, every new attorney needs upon graduation. And we're going to test this on the bar to make sure that your graduates actually develop those. That would be a sea change in legal education that I would absolutely love.
Yes, Don, and then we'll wrap up this part of the presentation.
Yeah, so going back to the organizing principles for domain content domains versus performance domains, because what I think this group is being asked to conclude is what is the organizing principle that we should follow. Now, the way it's written on the agenda is organizing principles for classification of knowledge domains and skills for the surveys. But what I think I heard Jim and Joshua saying is that somehow sort of whichever organizing principle we pick for the survey is going to impact how the bar exam looks. And so I think that if that is true, that how we organize the survey, whether we pick performance or content, guides what the bar exam is going to look like. The import of that question is a lot more significant, I think, than how we organize the survey. And I still don't know that the group has really been given a comprehensive understanding of the pros and cons of organizing it one way versus the other. So I just don't know if folks feel like they're in a position to actually answer that question, which way should we organize it, without a little bit more information.
I mean, I also think that the answer to that question has to take into account who you think the minimally competent lawyer is, right? Because until we come to some agreement about who that person is, I don't know, that we're going to be able to get very much further. And I mean, if my guy who graduates law school and hangs a shingle in Del Norte, California, is our known minimally competent lawyer, I think that I'm more inclined to test knowledge than skills. Because I want to know that they go hang a shingle and they actually know something about criminal procedure and criminal law and wills and trusts, because they're going to be giving people advice. And I want to make sure that they sort of get it and they know what the rules are and they kind of have some idea to apply them. If I'm assessing the minimum competence of somebody who's coming to join my firm, I don't care if they know any law. It makes absolutely no difference to me. I'd love for them to be like a normal person with a good handshake, and they can sort of talk in organized sentences and maybe write in English, right? Those are the things I'm looking for. But I don't know. But I think that we have to decide who the minimally competent lawyer is before we can figure out, what they need to do to prove their minimum competence, and then what our questions should look like to get at that. But that's just and I'm sensitive to your desire to move through the agenda, but I think that fundamentally, what I've heard is we're kind of an advisory board that's supposed to provide high-level advice and sort of comment on the work that you guys are going to do in developing the job analysis and testing and eventually coming up with exam questions. But I think that for us to do that well, we sort of have to understand what our scope is. And I also feel like if we are an advisory board, then the first question that we've been asked is how to formulate a survey question, which seems pretty deep in the weeds for the first question that gets asked in an advisory board. And so, I think that we could use a little bit more sort of high-level guidance on, what you want from us. And it seems like the first half of today was just orienting us, and then the second half is actually some areas where you guys want to solicit some feedback. But I think that part of what I'm hearing is maybe we are not sufficiently oriented yet to move on to the feedback providing part of the adventure. And that's just me, so everybody should weigh in and, say what they think, or that I'm crazy.
Let me give my overview at this point. First of all, I think you're right in one sense that we don't want to be slaves to a timeline for getting through this meeting. But I think that we all have our lives to lead and our planes to catch and other things. So I don't want to just let a discussion kind of flow on, and we either have to cut off two parts of the agenda that we never get to, or we're here until 6 o'clock still kind of, kicking a lot of ideas around. So that's why I'm fairly insistent on staying on schedule for the purposes of this and all meetings that I chair. Second point is, I'm not sure that we're looking for a definition from this group today of what minimum competence is, or answering any of the other questions definitively. I think my impression is what the consultants, Ron, are looking for is our initial reactions to some of these things, which I think we're getting some very good feedback on. We don't have the, I don't think, at least I don't feel as though we have the background material or the opportunity to review it and form strong opinions on it to some of these questions so far. I think this is more of an introductory session. So if I'm wrong and we need to drill down on any of these topics to a much greater degree than we already are, I'll be happy to reorient my thinking about how we structure the rest of this meeting. But I think you were just looking for our kind of initial reactions from this group of people, right?
Yes.
You're correct.
Okay.
Maybe as staff supporting the consultant and the coordinating with the working group, my own sense is all of these discussions reflect your different point of views, and then for a introduction to this project, largely at a very high level, all of these are very valid concerns and interesting point of views, and we are taking them all in. And as a matter of fact, a lot of these points in the distinction between knowledge versus skills, the extent to which the knowledge needs to be memorized, they have been considered and also were considered in the previous content validation study. So it's important for us to keep all of these in mind and then be able to address more specifically as we get into the more detailed level in survey development, in laying out the entire project plan. And in my own mind, in terms of the distinction between knowledge and skill is somewhat blurred in my own experience. It's almost like reading something and learning it, but you don't feel like you actually know it until you use it in different contexts. So somewhat it's an artificial distinction between knowledge and skill. Without knowledge, you can't really have skill. Without the skill of using it, it's really not a very useful knowledge. Maybe another way of putting it is Gilbert Wright, I like the distinction best, which is, he says it's knowing that versus knowing how. You got to have the knowledge and then you know how to use it. So we have all of these important distinctions in mind so that when we actually are developing the survey, we'll make sure to capture that. Actually, in one of the rating scales, we were thinking about it is the extent to which the knowledge you apply for the task you're performing relies on memorization of the knowledge. So that's all of a way of tapping into these very important dimensions in all of the discussions you're having now. So we definitely have more information as we get into the detailed discussion about the survey instrument development and classifications of the domains.
But I will say this, this discussion does highlight the fact that there may be a completely different way that we end up going off at the end of the day with the bar examination. I mean, this is a very exciting kind of starting point, and I really welcome everybody's points of view on the various, the importance of the various components of what we're going to be testing on eventually.
So are we ready to move on to the next topic? Is that what I'm hearing?
If there's anything else that you need to cover on this, go ahead, but otherwise, I think we're probably ready to move on.
Okay.
As soon as you are.
Sounds good.
May I quickly just ask, are we going to come back to this conversation at some point and discuss this in more detail? Because obviously we left it open and there are a lot of different opinions. So will there be a further discussion maybe in February about content versus performance? Or is this, you're going to take this information and use it to make that decision?
I wouldn't say to use it just to make a decision. Whenever we have a final draft on something, we'll definitely get the feedback from the working group before finalizing it.
So this is the final discussion on this topic. On the
in terms of the timing of the different activities, in February we're planning for the panel meeting, but we're also trying to schedule the second working group meeting in February. Later on, I'll just give you a few potential meeting dates so that we could meet every 2 months. Or if necessary, we could have a conference call in between, depending on the different milestones that we have to achieve.
Just to follow up on Emily, UCLA, sort of what Sarah is asking, I agree with. I mean, if this is, you are now going to go back and decide we're going to start with performance or we're going to start with topic, and then in February we're going to see a draft of whatever survey you have made based on what decision that is. I would like to know that in case we are then have the opportunity to either email you more information or have a conference call, or because I agree, I would like to. I've been talking a lot. I'd much rather hear from other people about kind of what they think. Like I feel like this should be, as Donna had said, like this is pretty instrumental in how the exam goes. So we'd really like to hear more, kind of a more rigorous discussion. Again, I understand it can't necessarily be today, but.
This is Margie, participating as a public member today. I just want to again reiterate my opinion that it's really important to also focus on performance because, I mean, I feel like there's such a varied, what people practice is so varied. You know, in my committee, for example, you need to be an attorney to work here, but you're drafting analyses of legislation. We're writing legislation. That's completely different than a lot of the other stuff that attorneys do, immigration attorneys, you need to be able to, deal with clients in different languages and, have different cultural competencies. That's also what you need to do in other fields as well. And so maybe I didn't completely follow the entire discussion, but I don't think that we're at a point where it's clear to me whether we should be going in one direction or the other in terms of focusing a survey on content or performance.
Just to wrap up the
I would really
conversation,
benefit from reviewing materials, and I apologize I wasn't involved in the beginning because I was on the bar needs to do a better job at scheduling these meetings because I'm also on this other task force that was meeting at the exact same time from 10 to 3. So I am not at a place where I can make a meaningful contribution beyond just what I have already said about, looking at performance.
just to kind of wrap up the conversation around that, because I think we're trying to move on, I believe. The line in there that says that organizing principles for classification of knowledge domains and skills for surveys, ultimately what goes on the survey becomes the content outline. I know there was some confusion about whether what's on the, if what was on the survey would be different from the final product. It would likely be different, but it's the same organizing framework being validated. So once it's validated, it might change slightly, but the general framework would stay the same. I want to...
Well, Jason, before you move on, are you now through with this topic area, Agenda H?
I believe so.
Okay. Let's come back to the question that Sarah and Emily asked, though, just so I'm at least more certain than I am. What was the purpose of raising these issues for today? Did you get the information that you needed, or do we need to have further discussion on the topic so that you have a clear sense of this working group's feelings, if there is one, and I'm not sure that there is one, but I just don't want, we have at least two members of this working group who are suggesting that we need to spend a little bit more time. And if there's nothing to be gained by spending more time because you're either not far enough along in your thinking or it doesn't matter or whatever, let's don't do it. But if there's some value to be gained, then let's spend a little bit more time and we'll cut some time off somewhere else. But I want to make sure that we're satisfied that we know at least where we are, and I'm not, as I sit here, satisfied with that yet. Okay.
So this is Jim, and I feel like I am surprised at the possibility that this question has brought about. This discussion has brought about the possibility of a sea change in the way the bar exam is focused, and so that is a question with far larger implications than I had in mind when I raised the question about the content outline. So what I would suggest is that let me think this through. Let me reflect on this conversation about the kinds of needs that we have going forward, and then we will bring it back up after I've had a chance to formulate a better structure for the conversation so that we can tackle this and get some reasonable conclusion that all of us are satisfied with. I'm not
with
all prepared.
Sorry, Jim. With all due respect, I don't think that that's direction that you should be giving this group. I think that that's direction that we should get from the bar. I mean, what's the bar looking for, right? And I mean, I'm surprised that you're surprised that everybody's sitting around here going, the bar's broken, because pretty much everybody knows the bar's broken. But do you, like, what do you want from the group?
Actually, that's why I thought we were here too, because what does it mean today to be a minimally competent lawyer when you go out and get registered to start practicing law by taking the bar exam? And the fact that our pass rates are plummeting and that people aren't satisfied going out into the world with the knowledge and training they have, or they don't know what to take in law school. I mean, I'm a parent of a recent graduate. She didn't take some of the subjects on the bar exam because, like the professor over there said, or the dean of law school said, she knew what she wanted to do, and we all specialize now so much more. I don't agree that we should necessarily be training the person in Del Norte that's going to go do every subject matter. I mean, if that person wants to do that, at least they have to know how to learn, how to have the skills to go learn a subject matter if a client walks in the door and needs that kind of help. We're not going to be able to train them to do 47 different varieties of law to the depth that a competent attorney would know them. It's not possible. It's just not possible. So I thought we should be talking about, well, what's the bar exam need to test now? What's that mean?
Eli? Yeah, this is all very, very fascinating, but I just want to point back to the scope of this working group and the scope of the study. We're doing that practice analysis that might influence further studies, that might influence how the questions are formulated at the bar, and what we're talking in terms of content versus performance, and is whether or not what's the first sort of level of category somebody's going to look at when they're responding to a survey, that they get on this innovative method that they're going to get on their phone or their email. So it's exciting because it's an innovative survey that we're going to get really more precise information about what attorneys actually do. We have to decide how the questions we ask inform our study in terms of how that's going to influence what sort of information we get, and that later on can influence the questions on the bar. But I also want to sort of not to bring this away from this idea that the two have to be mutually exclusive. The question is which categories people are going to be seeing first. Just because you're seeing performance doesn't mean we're just getting rid of any sort of idea we're going to be studying what content is relevant. We're also trying to gather that information. We're talking about study design, and we're not talking about the scope of this working group, to my knowledge, and please correct me if I'm wrong, is about the study and not about the actual questions being formulated on the bar and how the bar exam is administered.
Cool. And I also think that it sounds like the group could benefit from some guidance on what the goals of the job analysis are. And we ran through those earlier. You had in your PowerPoint presentation, maybe we could bring those up just to jog everybody's memory about what the goal of this task is. It was in the presentation that you did.
That I had?
Yeah, that you had. It was
Some of the questions raised about the purpose of this working group in terms of what needs to be tested on the exam. That's exactly what we're trying to use the information from practice analysis to inform as a next step the question about what needs to be covered on the bar exam and in what format that's the best way to test those knowledges and skills as reflected from the practice analysis survey.
Jim, this is Alan. I think your proposal is a good one. I think if we're going to have this conversation, your input would be a useful starting point. So I encourage you to do that. And John, I agree. I mean, I think ultimately we're going to be the oversight group for this particular study that is part of the overall look at the bar exam. I don't know that we are going to be deciding what the bar exam is going to look like. That's probably not the purview of this group. But we are overviewing and providing oversight for the job, California Attorney Practice Analysis Study.
And just if I could ask a follow-up question, because I feel like I'm getting mixed messages. Eli, you're talking about we're giving information about how the survey should be formulated and not to get too far afield and into the exam. But then I hear that how the survey is formulated and the results from that survey will in fact inform the exam. So therefore, whatever we provide in terms of oversight and analysis about what the survey should look like is a precursor to what the exam should look like or will look like. So it seems important that we do talk about it, not just through the lens of the survey, but through the broader lens of the survey leading to potential changes to the exam based on what we discover. So it's helpful for me to know how we formulate the survey, what kind of effect can that have on the information and data gathered in terms of what it might mean for changes to the exam. Does framing things performance over content lead to a different set of data or different outcomes than if we did content versus performance? Because that is going to change how we think about the actual questions on the exam. So I don't think we could focus just on the survey. I think it needs to be a broader conversation if I'm understanding what the survey will eventually lead to.
Right, we wouldn't be responsibly advising you on what to put in the survey if we don't know what your goal is, so we kind of need it instantly.
Yes, the how it's structured for the survey ultimately leads to how the content is structured in the exam, what we would call an exam blueprint or a test content outline. The survey is a means of validating what's going to be on the test, or how the test is going to be structured, organized.
Actually, I have one last question. I have a question. That was a very good point, Jackie. Thank you very much. And I stand corrected in that the scope of this actually is larger than what I'm focusing on in my work. But if there were both parts of it in the survey and we gathered data on both performance and content, then wouldn't that decision be parlayed later on once we had both? And then the question becomes whether or not which one is more representative or which one's more valid is a good conversation. But if we're gathering both data, would then how it just influence this conversation as well?
I think it will benefit to follow what Jim recommended, that we go back to reflect on all of the questions raised and reformulate it so that we have sufficient information for everyone to come back and then have a follow-up discussion and make conclusions about all of these questions raised.
This is Emily at UCLA. Jim, if it's possible, when you rethink of this or think about it, if you can, I think Donna's idea about having some examples would be very helpful. Like take us through a domain, a task, a knowledge statement, each way that might happen, how we might actually get at the content. If we start with performance, how we actually might get to the performance if we start with content. I am an experiential learner, so that would be helpful for me if that's at all possible.
Sure, that makes a lot of sense. We'd be happy to try to do that. There are more nuts and bolts kinds of things that it would be helpful for us to talk about. So if the chair is ready to progress, I think we might be.
The chair is.
And so the preparation for the panel meeting, and again, defining the different groups involved here. We're talking about a different group from the one that's presently assembled in the room. And this is a group that we need to look to do the work of developing an outline along the lines that this group ultimately prefers. And so they are a group that will expect to come to the meeting to write. And once stuff is drafted, they'll be reviewing it as a group in the whole, reaching consensus on all the different elements of the outline that they put together. So as a working group, we want to make sure that that group has a breadth of perspective that will allow for the practice of law as it exists in many different settings in the state to be brought to the table. The discussions in this panel meeting are going to resolve differences that exist because of difference in client type or specialty, or and we're not talking about any of the 13 specialties that the California Bar has defined as credentialing programs, but instead we're talking about the kind of specialization that you have all talked about in this meeting. And so who's at that table is a very important conversation. That's why we've listed the panel composition and recruitment strategies for developing this panel. And then the meeting materials booklet that we've drafted that you have available during this meeting, we're interested in getting your input on. And then we'll talk about my role in that meeting and things that I need to do beyond what we already have done. So the role of this panel is to serve as the working group. They will develop the content in the content outline, and so I'd like to talk about the seats at the table in that conversation and the ways that we can fill those seats. And so with the panel composition segment of this, what are the various practice areas? What are the ways that, or what are the variables that determine how the practice of law differs from setting to setting, from practitioner to practitioner, from client to client, from specialization to specialization.
What is the proposed size of the panel?
We have talked about a panel from 12 to 15 as being an optimal size. It can be a little larger, it could be a little smaller.
Greg?
Well, forgive me, but I think it gets back to the question that John raised and the judge raised earlier, which is, because who we want on that panel were the people that are actually familiar with what that does. I mean, if we're talking about bringing specialists in, or are we talking about testing and specialty in the practice? I still think that John has asked precisely the correct question, and if we don't get to the heart of that, we're not dealing with the basic issue. You know, as long as California gives a general license, it might be able to change. I mean, maybe Dean Frohl is right. There's a different licensing scheme, but you know, you have to ask what is the minimally competent lawyer skill set, and does that mean that if you have a general practice license, then you're able to go out and do anything in the law theoretically, and including if you're in the judge's court. So I think deciding who's on that panel makes it is a question that turns on what are you asking them to evaluate, or propose and to tell you what the domains are.
Oh, I thought you were waiting. Okay. Sarah?
Yeah, Sarah Cassidy. Yeah, I almost wish we could have some agreed upon stipulations about what it is that we're talking about, because if we have a separate panel that has even just a slight difference in what they're perceiving as the goal in this, we could really be working on two parallel different projects. So maybe it is something we need to come back to.
Ron, will this group be meeting before the panels, before the February panel date?
The panel meeting we are scheduling for late February. Panel meeting we're currently scheduled to happen in late February. This group's next meeting, based on the tentative dates, would happen around the same time. But depending on the specific issues we need to resolve, we need to look at the timing of the two meetings. Dates have not been determined. Jackie.
Jackie Gardina. I think both Sarah, John, and Greg are making great points, and I think even the idea that we are asked, or that the question is being posed through the lens of specialization, when you could ask for a panel that's based on firm, government, public interest, or other types of ways of practicing, suggests already that we're leaning towards a content analysis rather than something else. So I do think we need to ask and answer some preliminary questions.
And so this is Jim. I just want to clarify that when I used the term specialization a few minutes ago, I was not intending to make any reference to specialty certification for attorneys or to the 13 official California Bar designations in that sense at all. I've intended, as you talked to, the practice setting kind of consideration and practice area of law as more the thing that an individual develops a practice interest in. I used the word specialization, and I should not have. So I wish I could retract that. But what we're trying to do is to find a group that will be representative of the general practice of law in California. I think it's probably the best way to speak.
Hi, this is Margie Estrada. I am wondering, what do you mean by the general practice of law? Because there are some folks who think that what we do here in the legislature in terms of analyzing bills and writing the laws is not the practice of law. So would that be part of the definition? I mean, I want to make sure that we're broad enough because you do need to be an attorney to do what we do here. It's not just going into a courtroom.
So according to the definition of what an attorney is in section 6180.14, as put into the instruction booklet, we're talking about that being an attorney, and that a person who fits that definition and is licensed to practice law in California, and the variety of things that that person is qualified to do.
Yeah, I mean, it's Stephen Ferrolo. We're talking about 12 to 15 people, okay? They need to be licensed California attorneys. I assume it's not like the last study where you wanted people like who are really junior. You want people who are experienced, recognized practitioners in California who represent the variety of things that California licensed attorneys do. I don't think it's a hard thing to come up with 12 or 15. And I don't think it's making a choice between performance and skills. So you get some people from the private sector, the public sector, okay, various things in the public sector, including people who are serving in the legislature. You get people from large firms and small firms and individual practitioners. You get people who are highly specialized. You get people who do have generals, shiggles out there. And I think we could agree on a group of 12 to 15 people who are recognized either statewide or in their communities as strong practitioners. I don't have a problem with a panel like that. Does anybody else?
Sarah.
Sarah Cassidy. So
So I think the fact that we're having this discussion at all shows that there is some disagreement or ambiguity over what a subject matter expert is. And I would like to see a definition or a description of what qualifies as a subject matter expert. And in that same vein, just to have continuity between what our panel is doing and what the subject matter experts are doing, I would like to see this panel have some oversight over who those selected people would be.
I agree with that last comment, and I'd also add too as well. I agree with Stephen that it seems easy, but I also would say that if we're looking for 12 to 15 people, it might be helpful to see if there's any stats or surveys of, say, how many attorneys in the state of California practice in a large size firm, how many attorneys in the state of California practice in the judiciary, how many people are in law school in terms of faculty, things like that, so that we get a better idea of how many slots to fill for each category. Do we have any of that kind of information on hand?
Again, I think there's maybe another way. We know in our own communities. So, for example, I'm from San Diego, okay, and the San Diego Bar Association every year picks the people who are regarded by other lawyers in the community as top practitioners. I know that same exists across the state. Isn't that a place where we'd start? I don't think we can't make this completely scientific. If we want to do something like that, we'll probably have to delay it by about 6 months. But I do think that there's a base of people in each of our communities that we can who are recognized. We don't need to define what a specialist is because the legal community says who those specialists are. In San Diego, every year, the San Diego County Bar Association puts something. These are the people who are recognized as the best family lawyers in San Diego, and we have similar studies statewide. It seems to be you draw on a pool like that, and that should be reasonably representative of practitioners in our state.
Janae?
Can we be the working panel? I mean, I don't want to take on extra work for people, but I mean, we don't have lives, right? That's why but I'm just playing. But is there a conflict?
We appreciate, yes, you're the working group member participating as part of the panel. We don't exclude you from.
My impression is that anyone on this working group is invited to be on it if they would like. But it's not a requirement of being on this that you also serve on the same panel. Emily?
So I just want to clarify then what we're looking for, because I think there are definitely, hopefully all of us would want to participate, and that's 12 to 15. So if we're all participating, and maybe there's some, again, that aren't, but are we then truly then looking for subject matter experts also to help?
No, I should clarify the term subject matter experts. This term is a generic term used in a lot of projects. For staff participating in case management system, they know the subject of what they are doing. They're called SMEs, subject matter experts. It's different than the term expert used in the trial, expert witness. It's a completely different connotation. So subject matter experts is simply attorneys. And we're gathering together attorneys with a lot of experience from different practice areas. And then getting back to Sunil's question about distribution of different practices in terms of firm size, we have survey data that we could use as a way of trying to come up with a balanced mixture of attorneys from different firm types and practice areas.
Because I guess I would also say that an expert that would be helpful in this conversation when we start to think about sort of the task is somebody in, doesn't have to be big law, but law firms that are sort of the people that mentor associates and actually run associate programs that are actually working on the day-to-day to build and professionalize people that have just come out there. That expertise would be helpful, and or career services folks that work in law schools, or recruiting firms, or somebody that really for a living studies and works with and professionalizes sort of once they've passed the bar kind of where they are. I just think that it doesn't have to necessarily be on the committee, but I think that information would be helpful.
That's perfect input in this conversation.
Go ahead. Jim, go ahead.
I just said that is perfect input into this conversation. People like that that we need to identify and recruit?
I think we're kind of saying the same thing from a number of different perspectives, but mine is I would certainly like to have some people who are, for instance, mid-level or associates or junior partners in larger firms who have direct supervisorial responsibility over entering associates. Somewhat the same kind of functional equivalent in either smaller firms or I don't know who actually evaluates people who, for instance, go out on their own and hang up their own shingle. It might be the judge.
The state bar.
Very often would be, or people like that, and certainly you could have that in the legal services organization sector as well. But those are some of the people that I would think that we would want to have, people whose responsibilities are evaluating how well prepared a first-year associate is, for instance.
This is Glenn Risa. I'm going to make a recommendation outside the box here. We're in California. And for example, my wife she runs technology at 20th Century Fox. And on her lot, there aren't just hundreds of lawyers, there's thousands of lawyers, thousands. And they work in contract, and they work in IP, and they work in labor, the entire gamut of non-courtroom lawyering. And there needs to be somebody both in entertainment and up north perhaps in IT that represents tens of thousands of young lawyers who take these jobs in these industries which aren't law firm people.
Maybe, here's another thought. Somebody from the Office of Chief Trial Counsel here who's familiar with all of the problems that young associates or young attorneys get into. I think that's a somewhat jocular thought. But it might be worthwhile to get some statistical analysis, if we have it, from the OCTC about where problem areas are that may inform some lack of understanding or problem areas when people start out on their own. Yes, sir.
This is, oh.
Go ahead, Margie.
Sorry, sorry about that. Yeah, Margie Estrada. I just want to also, state that it's important not to just, focus, I think everybody's saying this, on firms, to also focus on the sort of legal aid organizations that struggle, and don't have that same structure that the big firms have, or even the mid-sized firms have. So it's very important, I think, to get that perspective on whatever, panels created, and also important to get, an immigration practitioner on there as well. Or, and others who aren't just practicing, before the state court. You might have a bankruptcy attorney or someone, who's practicing immigration law. You don't necessarily have to be a member of the bar of the state of California to do that. But it's important work, and we do have a lot of people doing that, especially right now.
Okay, thank you. Aaron, did you hear your hand?
Yeah, and I just wanted, this is Aaron from Access Lex. I wanted to build on Emily's suggestion that we have legal educators, or at least one on the panel, particularly those people who prepare students to go out into the profession. They can talk about the signals they get from employers and others about what skills are important. And then also, and I don't know exactly how we would go about doing this, but how about consumers of legal services? So clients, in other words. How about having somebody who's been on the other side of that talk about the skills and abilities and those things that were most valuable to them as they were actually retaining a lawyer and again, consuming legal services.
Like Aunt Mabel.
I guess I'm not sure. So it sounds like you get a bunch of people into a room and you make a huge Venn diagram, right? You get people from all these different areas of law, and everybody sort of says, well, to do my thing, you need to have this skill set, right? And then you make big bubbles, and then hopefully there's going to be some point where most of the bubbles intersect, and they're going to be, right? But I don't know that it follows logically that if you have the skills that are in the middle of the bubble, you're a minimally competent lawyer. And so I feel like there are some fundamental questions that have to be answered by us or somebody else before you can embark on this exercise. What is there such a thing as a minimally competent lawyer anymore? Because we spent the last 20 minutes talking about how the practice of various different kinds of law are wildly different and require wildly different skill sets.
What would your definition of a minimally competent lawyer be?
This is actually the thing that I was very curious about in coming here was what were we going to be able to get to one? And I mean, I guess that I tentatively, without having really thought about it very much, I think that if you can go out and hang a shingle and provide effective counsel to the folks in your town, you can probably go do any of the other things and be okay. But I'm not sure that, I know that we get a lot of people at work who should not go hang a shingle because they are not ready to do anything on their own. But I think that without deciding that as a bar and saying, hey, we have an idea of who we think should be given a license to practice law, if that license is totally unfettered and you can do any kind of law that you want to, it's hard for us to do anything.
See, I just I don't know. I don't know that we could come up with a definition of what a minimally competent lawyer is for purposes of practicing in the state of California that would inform how we test on the bar exam.
Well, that's what the bar exam.
We actually we came up with the definition. I was on the standard setting, did the standard setting survey and was on that group of 20 that had to read essays and figure out if the essay was a minimally competent attorney. And the definition was provided to us by the state bar, and we tried, Ron, you can speak better to this than I can, but we tweaked it a little bit, and we did come up with a definition. I don't think everybody was happy with it, but it was a starting point at least, and I don't know if that can be shared with this group or we're supposed to come up with our own, but I agree with John that we are sort of, at least at the standard setting, I wasn't happy with the definition necessarily, although I don't think it was horrible, but I think we don't really have a framework here, so I don't know if we can use that same definition or if we...
I think the issue here is minimum competent definition is very important, but then practice analysis is essentially trying to use empirical information to have a more rigorous and comprehensive answer on that question, rather than to have the definition and then do the analysis. I think the logical order is in reverse.
So why is it on our agenda, though, to talk about?
Minimum competence as a way of using the information from the practice analysis, and what's the best way of structuring the survey so that we can have the information to answer that question.
Okay.
Maybe the item wasn't framed properly to get the appropriate focus.
That's okay.
All right, here we go. John, next.
Jim, do we want to move on and chat about the rating scales before we get some feedback on those, or is there something else that you would prefer to get feedback on at this juncture? Jim, are you there?
Okay, well.
I'm sorry. Had you on mute. I was talking and you didn't hear me. We've got a lot of things that are that are things that this group can weigh in on. I do feel like that the rating scales may be premature at this time, given the conversations that we had, an hour or so ago. And it might be better for us to talk more about the major steps in the survey and the sampling strategy topic that is listed at the bottom there, and instead of the rating scales themselves. We did prepare a set, but I feel like we need to get a little farther in our discussions and understanding before we decide on those things.
Okay. Do we? You're referring to the two option sheet, so I can point everyone in the correct direction. Is that correct?
On the agenda, it talks about the sampling strategy, and then bullet points are beta survey, large-scale survey size, things like that. And we prepared a flyer or one-page preview about sampling strategy that might help with this. And I guess on that, there are a couple of questions that this group can help with. And the first of those is that one possibility is that we send a correspondence to every licensed attorney in the state, informing them that the practice analysis survey is going to be conducted beginning at a certain date, whatever date the survey is ready to launch, and ask and predict that it would take a half an hour or whatever the length of time ends up being that we think it will take for a person to give a thoughtful, complete response to the survey. And then ask if they would be willing to participate in the survey. That way, so the advantages, there are several advantages to that approach. One of them is that every attorney in the state will be given an opportunity to participate. So everybody will be able to say that they were asked to participate in the survey. Many of them, will not want to do that. But of those who ask, then having made a commitment to participate in the survey, they're more likely to complete it than if they just simply get an invitation to complete the survey out of the blue. And that commitment might help to improve the response rate. We would ask only people who said yes to that request to participate. The disadvantage is self-selection, which is going to be a disadvantage no matter whether we do the preliminary commitment or not. Self-selection always biases the response to some degree because people who choose to respond to surveys are people who are able to devote the time and energy to doing it and perhaps have an interest in it. And so that might be some interesting subset of the population of attorneys. And then a second strategy or second set of considerations has to do with random selection and random assignment. The first question is, should we solicit an a priori commitment from attorneys in the state to participate in the survey?
What's the downside of random selection?
There's not really a downside to random selection. the advantage of random selection is that because it's random, there's no pattern, there's no system, and so there's no reason to think that one group is favored or disadvantaged in any way in the selection process or the inclusion process. The risk you run in doing a random selection is that the sample might not be large enough to get a sufficient response to be able to generalize back to the population. And that is an issue more of sample size than it is random selection. But we do need to have enough people complete this survey to be able to generalize back to the population of licensed attorneys in the state.
Do we know what that number is?
So I would say that a large sample of approximately 6,000, given by, and Ron, you've got the specific information on the rate of response to other bar surveys that have been done.
It's about 8 to 10%. So to get 6,000 responses, you will have to have a population that we sent out to 60,000.
Jim, this is Emily at UCLA. Which is there any different impact on the diversity of folks and responses that we would get in the sense of, I understand the random sampling you indicated might have a different impact on small practice areas, but what about just sort of, all the demographics you can think of? Is it better to do, every single person, better to do, random to make sure that we have, all sort of demographics as much as possible responding?
So, the fact is that we don't have data at our fingertips that can allow us to sample into the different practice areas. But when there are small demographic groups, like say small practice areas or small ethnic populations, or whatever the variable might be, if it's an important area, then we can oversample in that area. That way stratify the random selection. And that way we can oversample in that area to improve the probability of getting enough response to be able to do meaningful comparison.
I guess just methodologically, I still don't really understand, even if you have a representative sample, right? That if you take a representative sample and then you make the Venn diagram, that the skills that exist in the middle of the Venn diagram are the things that you should be testing for, and that those are both necessary and, more importantly, a sufficient set of skills to get somebody to pass the bar. Like, does that make any sense, or you're just talking nonsense?
I think that part comes from the rating, the analysis of the rating. We talked about the rating in terms of the frequency and importance, criticality. All of those will help us summarize the variety of different skills and knowledge in order to make a determination about what out of the survey that identify the different knowledge, the Venn diagram, the overlaps. That's a way of identifying that.
And so the point that we're trying to address now is based on, it's called, we're trying to be able to generalize from the data that we collect to the full population of licensed attorneys in California. And if, in order to do that, we need to have meaningful response from the variety of practice areas and settings and people, so that we can say that we haven't left anybody out, that all of the different perspectives have been brought to the table.
This is Margie. My thoughts are, in order to accomplish that, not leaving anybody out and making sure that everybody has the opportunity to come to the table, to me it makes sense to allow participation by everyone.
Yeah, I just wanted to bring in another dimension, and I was going to raise this earlier, Jim. Earlier, you talked about demographics, and I want to press you a little bit on what you mean by demographics. Let me say a little bit about this. This was also the context where people were raising questions about, we're doing this analysis of what lawyers do in California, what services they provide, and we talked about, well, how different is California from other states? I don't think California is much different from other states in terms of the services that people provide. But I do think California is the services that lawyers provide, but I do think California is very different from nearly every other state in terms of the people to whom we provide those services. We are an incredibly diverse state. We're a state in which minorities are a majority. And we say here that this is a study to validate the work that attorneys perform as well as the knowledge they require to serve the public proficiently. We have a public which is different than the public in many states. And to serve them proficiently probably means having certain skills such as language skills and ties to communities. And how are we going to capture that? I think a lot about that as someone who lives in San Diego by the border. How are we going to capture that? Because there are skills that our attorneys are required to have because of the diversity of the population in the state, and serving the diversity of the population in the state, I think, different. And I would hope that we could somehow capture that, because that's a critical issue in our state in terms of access to justice and legal services.
This is Margie. I really appreciate that point, and I just wanted to also highlight that, how do we capture that when we do not have a diverse pool of attorneys? I think the last statistics I saw had Latinos being just 4% of attorneys in the state of California, whereas I believe the population of Latinos is closer to 40%. So I agree that's kind of a conundrum. How do we ensure that, there's a broad representation?
Well, I think we have to word the questions carefully, but there certainly can be a question or two that ask about the population that the attorneys serve, and they can break that out by, say, maybe we would list provide a list of population, ethnic populations, or however we want to list that, and ask them to indicate what percentage of their practice they devote to those different populations so that the total ends up being 100%. That's one way that we can go about getting a sense of the population served. And I do think that it's important to collect that information.
I would, it's Stephen again, I appreciate that, because I think that would tell us something. They might well say that there are different types of skills that are critical to serving. People who serve more of that population might say there are different skills that are critical to that population. And I think that's something that we as a state and a state bar should be attentive to, if that's the case.
Well, we can certainly use the demographic survey to collect the information. The questions that we ask in the analysis, though, are not going to be if the differences are statistically significant, but is a particular topic or task, not to reopen that conversation, important to the practice of attorneys who serve those different populations. And so we will look at group differences, but mostly to determine that the topics that are in the survey are pertinent to the practice of law as those groups are served. If we find that a group is group served makes a difference, then I think, we'll need to bring that back to this group to iron out. But it is an important question, and the demographic survey goes a long way toward providing information that can help us understand those areas.
Hi, this is Aaron from Access Lex again. Going back to the sampling question, I'm curious to know what are you all's recommendations about which direction we go in. I mean, I tend to like random sampling because it's not often you can do it, but then also you reduce a lot of the bias, the self-selection bias and all those types of things. And you, in theory, will capture the different practice areas, the different demographics and all of that in your random sample. And we have a pool of 250,000 attorneys. That's a very large and very vibrant, potentially vibrant pool of people to sample. So I'm just curious about what your recommendations are in terms of which direction we can go. It seems the random sampling is much more efficient and would have less bias.
But remember, yes, and I agree. I mean, if you're asking for my recommendation, I would say either survey everybody or do a random selection for some large sample of people to invite to participate in the survey, but we cannot compel participation in the survey. And so that is, we have to select a larger sample knowing that self-selection is going to be a factor no matter how we go about it. Just can't require people to complete surveys.
What if you had like shorter surveys and you just sent them to smaller subsets, so that, because instead of taking half an hour, it took 5 minutes, and then you had 6,000 people fill out one 5-minute survey, but you had whatever it is, 6 groups each filling out 6 groups of 5,000 people each filling out a 5-minute survey.
I'm so sorry. This is Margie. I can't hear whoever's speaking right now. Could you put the microphone closer?
The question was about shorter surveys to specific groups or populations, I believe. We sort of capture that a little bit with the ESM in terms of being able to, you're sending a much shorter, a single question essentially. The issue with breaking the survey into smaller pieces is then you're not getting feedback on the whole thing, just one section of it that you're sending out. So you would get just one part of the full content outline from whoever you sent it to.
Sarah Cassidy. So can the state bar incentivize taking surveys, such as by giving a CLE credit? That way you get the sampling of people, just not just the self-interested.
Yeah, we're talking about doing exactly that. We can't just, we would have to amend the NCLE rules to just say, if you take the survey, you get NCLE credit. And so we're not really prepared to do that. We're trying to figure out, we don't really have a lot of time to amend the rules to allow for that, but we're trying to figure out sort of how we can do it. We can create sort of like a self-study where if you're taking the survey, you have something to read. Maybe it's an article about how the practice of law has changed in the last 20 years. You read that, you take the survey, you get your hour and a half of NCLE credit. The other thing that we could do, the State Bar through our Commission on Professional Responsibility and Conduct every year puts on an ethics symposium, which is now available not just in person, but we stream it, so you can watch it online. What we were also considering as an option, and that would be like 4 hours of ethics credit, is if you do this, then you can attend that for free. So you'd have that ability. So we're trying to figure out what we can do, but NCLE, Sarah, is exactly what we were looking at to try and provide some incentive for folks to take this.
That's awesome.
Emily?
So a couple questions. One, based on that, what can the committee members do to help promote the survey once it's going? I mean, like, obviously we have some lists of alumni that we can send stuff out, but I guess that would be helpful to know what, not today, but at some point, what the committee can do to help promote people taking the survey. And I guess the other thing that I wanted to ask that I don't necessarily need an answer to, but just kind of if you have thoughts, is how the MPRE and the moral character application relate to any job analysis work that we might be doing that we wouldn't necessarily need to include in a survey or bar exam, in the sense of has anything been determined, for example, that honesty, integrity is something that I would say we would really like to see a minimally competent lawyer have, but to test that might actually be in the realm of moral character and not in the bar exam. Same maybe with the MPRE, where they have to do the MPRE, and so they're doing these ethics questions, but we still test, obviously, California rules on PR. So I guess I'm just wondering if there is, in addition to the bar exam, are there things that the state bar is requiring that sort of take it maybe necessarily out of the realm that the bar exam needs to be worried about, or at least that the job analysis needs to worry about?
So I can field that. So on the first question, that's only the first question went out of my head.
Just what can we do to help you?
Yeah, so we're going to have a communications person working with us, with this working group and the work that the group is doing on this job analysis. And so as we get closer to the time when we'd be releasing the survey, we can give you all language to send out, and we can give you the the communication tools to be able to spread the word about the survey to encourage folks to participate. I love your moral character example because I have a spot on response. The State Bar is about to put together an ad hoc working group on moral character to develop clear, transparent, consistent guidelines on moral character. We'll be looking for participation from members of the community bar examiners, the 3 classifications of law schools that we have here in California, maybe an expert in the field. We're sort of actually just sort of thinking about categories of people right now. And so that actually would tie very nicely in. We'd like to get that group started pretty soon, so we can, by the end of the 2019 calendar year, sort of develop more sort of consistent and clear and transparent guidelines on what it is we're looking for, to give guidance to the schools and to the applicants that if you have X, Y, and Z, that's likely to find that you don't possess the requisite moral character, or that you do possess the requisite moral character. Thank you.
Josh, Jason, anything further?
Jim, is there anything else specific that you would like to address? It sounds like the random, either random selection or using the full population seems to be a pretty popular choice in terms of sampling.
And we will have to make the decisions about that in conjunction with our staff, and what we don't have a sense of is the wisdom of sending correspondence to every licensed attorney, asking if they are willing to participate in the survey and moving along from that standpoint. We that way could get information. We could also ask those who, write that they are willing to give us to select which practice area out of the 12 listed that pertains to them. And that way we could stratify the selection process so that we make sure that we've got good participation from all of those areas. Is that so? So the question is, should we or should we not invite everyone to make an a priori commitment to completing the survey?
Greg?
Well, it seems to me that's a technical question because I think everybody wants to have valid data. The question is, what is Castle telling us is necessary in order to get the valid data? I mean, so if doing a random sampling will produce that in your experience and expertise, or if setting out and asking a question, I don't have anything to offer because that's a technical question. I think it's related to the survey.
So beyond the technical question, we also are not at a position to make the final decision because it partly depends on the incentive. If we have the incentive detail all worked out, probably have to give that opportunity to everyone rather than have only someone meeting certain criteria in order to benefit from that incentive. So all of these different options we'll take back and then pursue the incentive structure and the different considerations will bring us to the solution. As you said, that the ultimate goal is to have valid data.
Okay, Josh and Jim, any other issues you would like feedback from this group on? We have a few administrative matters to take care of at the end of this meeting.
I am good for what we've done, and I want to thank everybody for your wisdom and your willingness to live with some uncertainty about some of the questions that we've raised here, and we will follow up as promised through the conversation and look forward to our future conversations. Thank you very much.
Thank you, Jim.
Thank you. Josh, anything further?
No, that's it for me as well, and I thank you for your time. This is these are always challenging questions to answer, and we have to lean on you for the support because you are the experts. So thank you for your time, and that's all that I have.
Okay, thank you. Ron, you want to talk about the population of the panel and meetings and sequence and so forth?
So immediately, the first task for us is to come up with a strategy for selecting the panel members, identifying different stakeholder groups, and certainly the working group members are encouraged to participate, but then only after we have finalized the composition of the panel members, 12 or 15, in terms of the different mixture of different stakeholders. We'll send that information out to you. And some of the other issues that we discussed, specifically related to the performance-based or content-based design of the survey, we'll clarify, and if necessary, we'll schedule a follow-up meeting prior to the convening of the panel or somewhere around that. All of these dates at this point is uncertain, but I have a few of the future dates that's possible for us to meet every 2 months. So for now, would you please save those dates on the slides here, and I'll follow up to let you know the timing of the panel group meeting, the composition, and when we will like you to help or directly participate.
For those on the phone, the dates on the screen are February 27, April 24, and June 19.
They're all Wednesday.
Can you send those out? I couldn't hear you, Donna. Sorry.
Yeah, we'll send them to you. No problem.
For now, yeah.
Margie, were you able to receive the packet with the materials folder?
I was. I sent a thank you. Or is that what you're talking about? The one that you just sent me over?
Yeah. Awesome.
Yeah. Is it in? Are the dates in there?
They're not. We'll send a follow-up email to everybody with these dates. Yeah.
Thank you.
Just another housekeeping matter, real fast, is I made some typos in the roster and people's names, and I corrected that during lunch, and so I'm just going to hand out the corrected version to everybody right now that you can keep in your folder, and if you would be so willing to take out the old version, and so I could take those and put them far away, shred them. Yeah.
So for the working group member, anyone who is interested or wants to make a commitment to participate in the panel, would you raise your hand now? Okay.
This is Margie. I'm interested in participating in the panels. Is that what you just asked?
Yes.
Are those hard dates?
No.
Okay, February 27th, I don't be here.
Oh, here's your.
The panel is a 3-day commitment. 3-day.
You can keep this.
The date uncertain. I'm not sure.
We talked about those as possibilities, depending on what's more convenient for people to participate.
Okay, sir. Jackie.
Okay.
Is that going to be up here, Ron, San Francisco?
Not necessarily. Again, a matter of convenience. Okay, Jackie.
Anybody, all right, so anybody else who has a hand up, sorry. Who's interested? Steve?
Steve, Emily. Aaron?
Oh, Emily? Okay, Aaron.
Robbie also?
Yeah.
Okay.
Nancy? Robbie?
Yes.
Yeah.
Okay. Sarah, are you good?
I'd serve, but I don't know if you want me.
Sure. Okay. And John, anybody over here? Did you want to be on that? Greg?
Come on, John.
You'd love to, but no.
I have to check with my wife first of all.
Right, well, that's what it's
I'm not allowed
about.
to give away that paper block.
Okay. And anybody else? Greg, yes, no?
I said yes if, but
Okay.
if the question is going to go on to that.
Yeah. This isn't a definite, I mean, we just kind of got to get a feel, and then we can start balancing out, what we have here versus what else we might need. Okay. And if anybody changes their mind, just, or one way or the other, just email on. Okay, anything else for today? Probably left more open questions than we resolved, but at least we've gotten a start, and very glad for that. Yeah.
Another housekeeping matter, if you traveled here today and have an expense, I'm handling all of the expense reports that are in your folder, and they were also in the email that was sent out last week. So once you filled that out with your travel, and then you can send it back to me. The hotel accommodations were direct. Direct
That's
billing,
right.
so you can write
Right.
DB on that. And this is for the travel expenses. And you can email that back to me. Yeah, I'm happy to answer any of your
So
questions.
email copies of original receipts are okay?
Yes.
Okay.
Or email copies of original receipts. Yeah, scan works perfect, yeah.
Okay, unless there are any other questions or comments, we will stand adjourned. Thank you.
Thank you very much.
Thank you.
Thank you.
Thank you.
Margie Estrada has left the conference.
Jim Henderson.
Has left the conference.
Yeah, I love it. Yeah, I got two things. I got the remark. When I got this, this wrap. And so that also takes your notes. So this is like great curves like that. You can see it. I mean, it's got these like the using this recording. So which do you like better? So I'm.